Boom. Hey, everybody. So today we've got a guest because everyone was like, you need to hear this story. And I was like, I think I really do. So we've got Scott from Recovery Addict who is doing great coverage. And your channel's been growing hugely, hasn't it?
I pick
I
up a
haven't checked your
subscriber
numbers.
about almost every day. So no, it's been slow lately, but yeah, it's over 60,000. So we're super excited.
Nice. What is it? I've been picking up things slowly. I don't know what's going on with YouTube, but it seems like they're just seems like the algorithm hates me right now.
I was
So
half expecting you to be coming to me live from the hot tub today. I made the suggestion on
I
Twitter
don't
and thought maybe you'd
I
fly
don't
with it
own a hot tub.
next time.
So if I was gonna invest in something like that, I'd probably actually go with sauna rather than a hot tub. So yeah. And I got to apologize to the chat. I had a sort of meeting with my channel advisor, and they were like, hey, we'd like you to consider running ads on the thing. So I was like, okay, fine. So I've got ads turned on, but set to as minimal as possible. And so that way I can tell the channel advisor, hey, I tried it. And then we can go from there. But yeah, I'm not going to do any hot tub streams. I think that would
Break the
just
internet.
get my well, no, I think that would get my subscriber count to drop by exactly the number of people that watched it. So,
That's awesome.
yeah.
Well, it is awesome
So
to be here,
you
Ian. Thank you very much for the invite.
well, and you've got a bit of an amazing story here because somebody you may have had a major impact on a trial, I understand. So which trial is this that we're looking at?
Well, we were watching Sarah Boon, and people were blowing up my phone saying the trial we abandoned. We skipped out on Georgia versus Melody Ferris. They said you need to see this. Have you heard your name and have you heard you're being mentioned? I'm like, what's going on? So I found out this afternoon, like live on air, that something happened in the Georgia B. Ferris trial, which we're going to catch up on as soon as Sarah Boon's done here in a couple days, and so
Boone's
I
gonna be real
jumped to it and
fast.
watched it live. We did a little live stream, and I found out for myself what happened. Do you want me to just break it down for you?
Yeah, what's that trial about first, I guess is
Melody Ferris is a nice old lady, as a beautiful home, like Southern Living type show home. They're in Georgia. Gorgeous little ranch. Everything. Rich husband who's a lawyer. Worked long hours and put in a lot of money. Brought a lot home, and they spent like every penny of it. Had couple kids, 2 boys, 2 girls, who were pretty dependent on daddy for money for pretty much all their youth and adult lives. And then one day, dad is found dead in the burn pile. And there happen to be secrets. There are skeletons. There are affairs on both sides. There's a lot of spice to it. It's quite a bit of drama. And the way the state is telling the story, Melody, the wife, is the only one who had the opportunity and the motive to do it. There was a gun involved, a 38 snub nose. How they found out was after they found the body in the burn pit. They were, thinking, oh, it might have had a heart attack and fallen in because he liked to burn stuff, and then they found that bullet in the rib cage, the jacket
that'll
from the
do it.
bullet, and suddenly became a murder investigation. No significant blood in the house. Lots of questions unanswered, but she's got a jury trial saying it's not her, and trying to pin
I'm gonna
on
start
her
carrying a bullet
sons
around in my shirt
just in
pocket
case.
just so that if I ever end up in like a fire or something, they'll be like, "Oh, this is a murder now."
Yeah. Yeah, it's a wild trial. Some good lawyering. It's been pretty spicy, but what happened today was what caught our attention. Towards, I guess the judge found out Friday night that I believe Thursday the prosecution had got a call, and they got a call from Martha Jane, who's been mentioned in the trial. She's an 84-year-old lady. Melody would go to her house and take care of Martha Jane Well, she also was seeing her lover while she was still married, and running off, and so she went and took care of Martha Jane. And through the course of all the evidence, there was just the slightest reference to the fact that there were firearms at Martha Jane's house, and one of them was a 38. And I was sitting here watching court like I am right now. I normally have like a little window in the bottom, like you see right here. I just put on. That's how I watch stream the trial. I talk and I do what I do. And so I'm the man in the corner with the headphones, and I'm like, oh, I see where the lawyer's going here. I'm just sort of like verbalized during it. And I said, he's getting to where they're trying to say that Melody stole Martha Jane's 38 and used that. Well, that was pretty much what everyone else was thinking. That was not any detective work on my part. It seemed very obvious to me. And I just said out loud what everyone else was thinking. The only difference was I did not know this at the time, but Martha Jane was watching our live stream.
Oh, wow.
She's on the witness list, but had not been subpoenaed. And she shouldn't have been watching, so there's that issue. But now we've got...
Is she actually restricted if she hasn't been subpoenaed?
I don't think she ever was told not to. They argued that she shouldn't have been. Defense argued that she shouldn't have been. And I didn't hear exactly what happened on that today. It's still a blur for me. But I think it sounds to me like it's okay.
Yeah. That's amazing, though.
We like to run a friendly channel where, family and friends of victims and defendants can feel comfortable to watch. And that's what we try to do there. And so it's awesome that she was watching. But when I said, that's it, Martha Jane's 38, Melody in the basement, I've solved it sort of thing, she was watching, and it hit her conscience because she knew her gun was missing. And she hadn't told anybody. And the investigators came. They never asked. She had two guns. She had a 357 and a 38 special snub nose that were in this chest underneath the television in the guest bedroom where, you guessed it, Melody would stay when she came over to visit. And other items went missing, and she checked and looked for the gun, and the 38 was gone. The 357 was still there. And she never told anyone. So now her conscience found the best of her after I called her out by name while she was watching my channel. And she made the call to the detective and said, I have something to tell you. So now that's going to be going into court. She called me the man in the corner with the headphones of Court TV. They said I was on Court TV. But it was, went back and replayed me. I remember making the comment, went back and replayed me making the comment and everything. It's pretty obvious, but it's going to come up again Thursday when she shows up in court to testify. It just opens up a little window into the who could have done it side of things.
Wow. That is a huge thing. Yeah, and if she wasn't subpoenaed, I don't think she did anything wrong. I think she's just entitled to watch the stream, and yeah. Now I was doing a little experiment with ads, and because my partner manager was like, "You need to try that," and people are saying that they missed the story because an ad ran. So I have turned off the ads because that's just like, that's not okay. Yeah. Chat, if you're still getting ads at this point, hit refresh because I just told that to turn off. So yeah, your support keeps this channel going and keeps it ad free because yeah, but I guess for the people who missed it, somebody was watching Scott's stream and realized that their gun was probably critical to the case and is now going to be testifying. And how was it they described you? The man with the headphones in the corner?
The man in the corner with the headphones of Court TV. Well, Court TV is airing the show, but they don't have a man in the corner with the headphones. We found the clip where I said exactly that, and I call her out by name. I say Martha Jane's gun, her 38, Melody took, and she knew that they had gone missing. She actually said on the phone call to the detective that other items also went missing when Melody was there.
You might have helped cement a conviction there. That's
I'm not sure how I feel about that.
I mean, I don't see that you did anything wrong there. It's just you investigated the case and went, or you were watching the case and you went and put 2 and 2 together. And I
In
mean,
journalism school, they said, "Don't be the story." I'm like, I don't know. I don't know how I feel
the
about
thing
that.
is, it's not that you're the story here in the sense of like you haven't been arrested or anything like that. It's just somebody watching your coverage went, "Oh." So I think that's a different animal, because I mean that could happen really with anybody's sort of coverage, right? But
Yeah.
it is really awesome that you put 2 and 2 together there, and she's like, "Huh, I have a problem."
It's really neat. We're going to go back and follow that case through to the end, but it's
I
crazy.
feel like you pretty much have to now.
Yeah. Thanks, Court TV, by the way. They're great, but I'm not Court TV, just for the record.
Court TV is pretty awesome. So yeah, it's no, that is an amazing story. And I guess the next thing to talk about is Boon. You've been covering the Boon case?
I have. It for as long as we've been waiting for this, you would think there would be more to it than there is.
I knew there wasn't
going
going to be. And the thing is the Boon case is right now the bane of my existence, because not covering it is like flatlining everything else I do. But it's also like I looked at this from a distance and I was like, this is going to be a boring story. This is going to be a boring case. And really the only way it would be interesting was Sarah Boon,
pro se,
pro se, shouting out, objections and just being whatever. And, but I mean, now she's got counsel, and her counsel is doing the best they can. I wouldn't say that her counsel's incompetent or anything like that. They're just, you look like a crap poker player if you just draw 2s and 7s all evening, right? That's really what he's got. He's got an entire deck just for him that's like 2-7 offsuit, and he's playing a heck out of it. But
we were hoping for something spicy. I've got equipment down there. We partnered with Trial TV Live, so I sent my live view down. We're connected to the media pedestal, so we get a clean feed straight from court. And man, it's going to be over. The state's going to rest their case tomorrow morning. Sarah Boon's going to get on and testify. Defense might be done by the end of the day. I mean, it's going to be so quick. And Sarah Boon's been smiling in court like she knows something none of us do. And I think she's the one that might be a little misinformed here, because the fact pattern is not in her favor on this one in any way.
I think what's going to happen is she's been banking on the... So for the people not following it, Sarah Boon is accused of second-degree murder for locking her, or for zipping her, was it husband or just boyfriend? I can't remember.
Boyfriend. Yeah, I don't think they were married.
Yeah. Zips him up in a suitcase, laughs when he can't get out, hits him with a bat, flings him down the stairs, and then goes upstairs and goes to sleep, and he dies, which is not super surprising when he's in the suitcase going, "Sarah, I can't breathe. Sarah, let me out. Sarah."
Did you mention she filmed it?
Yeah, she filmed this, and she also did an extensive 3-hour interview with the police. And I've got this little rule of thumb when you're trying to determine because I do criminal defense. So when I'm trying to determine how screwed my client is, one of the rules of thumb for that is just you look at their interrogation video and you just open it. You don't even have to watch it. You just open it and you look at how long it is. And the longer the interrogation video, and you have to sort of prorate this a little bit for the severity of the crime, but the longer the interrogation video, the more likely your client is to get convicted. if you've got an interrogation video and it's 15 minutes, it's probably that your client's okay, unless it turns out to be 15 minutes of your client saying, yes, I did everything, and I'm going to sign a piece of paper that says that I did all the things. Sometimes that happens, and that's real unfortunate, but the more they talk, the more things are bad. And she really, really, really screwed herself. I see somebody in the chat saying, are there any examples of a short and sweet interrogation video where the person went free in the end? I have seen lots of them. It's just they're not ones I can share because they're all like my client sitting there. I mean, I had one where the guy just said 2 words the entire interrogation video. Those 2 words were fuck and you, that he repeated over and over and over again. Every time they asked him a question, he just said, that was it. Over and over and over and over again. It was like a half hour of that. And they really wanted to get him, but that was all he said. And it was excellent. The prosecutor then tried to introduce that video. And the judge was like, I get how you might want this in because it clearly makes the guy look bad, but it has no bearing on whether...
No relevance.
Yeah, no relevance whatsoever to whether he committed the offense or didn't commit the offense. So it's just prejudicial. That's the only reason you want it in, prosecutor. So it doesn't go in. And yeah, the prosecutor was super upset by that. But yeah, they didn't have enough evidence to do anything on that. And it was lovely. I wish it was ethical to buy clients something when they do that. So then I could just tell a client, listen, if you manage to get through that interview and you keep your mouth shut, I will I'll buy you an Xbox or something, and then they could be sitting there in that interview going, I really want that Xbox. So I'm going to keep
something to focus on instead of opening their mouth and ruining their case.
Yeah. But I don't think that would be ethical. So yeah, so I said that I would do a really quick Sarah Boon recap. And so I guess we'll do that. First of all, we got the opening statements. And the opening statements were entirely skippable. They neither side was hilariously incompetent. Neither side was amazing. They just kind of went through their version of events. The one mistake I thought the prosecution made was they started to get into the weeds a little bit where they're like, and you're going to hear some stuff about her arguing self-defense. And I was like, dude, they might not even get to argue that. Why are you telling the jury self-defense when they might not get to say it? Why put it in their heads? It wasn't fatal, I don't think. Did you get the same impression on that one?
It seemed weird. He was rambling at the end on prosecution. It seemed like he was just trying to fill up time, and he needed to probably sit down. I thought he did great up to then. He could have been done and just said, "We want you to find guilty," and sat down. Already, we knew that prosecution or the defense had been hamstrung. None of their displays were allowed in. Even the stuff where they're just citing the law, they did the citations wrong. Those were struck. They couldn't show any of their pictures they had printed out. It was a win already.
The wrong law thing was hilarious. So for the people who haven't been watching, the defense brought in a section of the jury instructions, and they're like, I just want to show this to the jury. And the judge is like, I would totally allow that if that was the correct jury instruction, which it's not. So you don't get to use that. They had all of this, show and tell stuff that, including pictures of Sarah Boon's injuries and stuff like that. And the judge is just like, nope. I said you could argue the issue of battered spouse, I didn't say you could bring in all the pictures. Like, those are not admissible at this point. So, nope. And he's like, but I thought you said that was okay. And the judge is like, no, that is not what I said.
I do like this judge. He is so good. He runs a tight ship in the courtroom, and
he puts up with no bullshit, but he puts up with no bullshit in a very friendly, polite, like, he can tell you, like, fuck you, no, and he does it in a way where you're like, thank you, judge.
I understand. Yes, I believe you're right. Yep. He's good. He's really good. He's refreshing to watch when you've seen so many judges that will say, I'm going to lay down the law, and then they don't. And the lawyers run roughshod over the courtroom. And, you know, it's frustrating that way. This guy does it. He kicked somebody out of court, a viewer today.
That.
Out.
And that was, like, we don't know what it was, because, like, all of the people I know of who were normally in, like, sitting in the courtroom watching weren't able to be watching. But there was some issue with the judge. Like, both sides basically said this one person in the courtroom is causing a disturbance. We want her gone. And the judge is like, agreed. Yeet. And she had some back talk for the judge. And the judge is like, that's nice, but also you're leaving. Like, there is nothing you could say that is convincing me otherwise. And I liked how he was sitting there going, you are welcome to watch this trial from any of the streaming services out there. It is being live streamed. You can watch it from there, but you are not, you know, you don't have to go home, but you can't stay here.
He even volunteered as judicial assistant. You know, call her. She'll tell you how you can watch it on a live stream, but you're gone.
Yeah, that's what I mean about him being, like, super nice as he says no and as he lays down the law. But he doesn't take any arguments. When he makes a ruling, it's the ruling. And he's fair to both sides.
I saw somebody asked if it was the sunglasses were the issue. I don't think they were. This lady, I saw a reporter from a local reporter says that she came into court and said, is this the Sarah Boon trial? She was like yelling, is this a Sarah Boon trial? She just walks in. And when Sarah Boon was let in, she said, they think it was to the bailiff, you should be fired, or something like that. And I'm not sure if she meant to Sarah Boon or what. And so there might be some mental stability issues as well, because it didn't really add up as far as even what she said when she was kicked out of court. It sounded a little bit like, I mean, preaching, like a scripture reference. And it was odd. It was just an odd moment altogether.
That sounds like a that sounds like maybe a mental health thing. So what can you do, I guess? But yeah, I mean, and a trial like this might attract that kind of issue. So this I'll just raise here. Cheryl Ray says we may get lucky on Judge Bev. Her appointment is done in January. She was the boss and she has to change circuits, except for one little problem that she's got. That little problem that she's got is that they are keeping her on. Apparently, some people reached out and apparently they are keeping her because she's on the Karen Reed trial for the retrial. And I get why. The why is that she would have put so much time into getting the background. She's heard all of the motions. She's heard all of those things. She's all of those things. So they don't want to get a new person on that. But at the end of the day, it's still like, we don't like her.
Look at the Young Thug case where they got a new lawyer or a new judge in, and everything that's sort of being relitigated that they had to sort of litigate before with the other judge. It would be that same sort of thing, trying to catch the new judge up to speed and try to regain ground that was lost previously. It would be a mess.
Yeah, and I mean the Young Thug trial is going to be the world's most expensive mistrial.
Mhm.
I don't see how that one gets to a verdict at this point. It's it's
When
a
it blows
bath.
up, it will be epic. It's gonna the fireworks. You'll hear them all around the world. It's gonna be so good.
Oh well, I mean, some people should get fired over that one because it's just insane. I kind of wish I'd started that one at the beginning, but it's like 100 and something days in, and
Why don't
people
you
are like,
try it on
"Oh,
catch up?
be up on the Young Thug trial," and I'm like, "How?"
You just skip like one of the first few days in court, where they got Zoom bombs with the adult film. That one got me. That was the first day I tried to cover it and had to delete my stream because it was shown. It took me about 27 seconds to delete my YouTube stream for the day, so I didn't lose my channel because it was not good. It was not good.
Yeah, that's becoming more and more of a problem too. There was a bail hearing here in Canada that repeatedly got Zoom bombed with gay porn, and eventually the judge was like, "We're closing this Zoom except to like the lawyers and the the parties." But yeah, that's nasty for streamers. The other one that's caught a lot of people was the Rust trial. A lot of people got caught on the Hannah Gutierrez trial. Two moments that caught a lot of people. One, Morrissey drops the C word, and YouTube really doesn't like the C word. And the other one was the in sentencing, that little memorial with the music.
Oh man, those are the worst.
Now I knew it was coming, so I'm like, we're muting this because it's music, but a ton of people got copyright strikes from the owner of that song, and it was just like, oh, that's bad. Yellow Pill is saying, what happened with the Zoom bombing? Somebody played Spicy Films on the Zoom, and it caught Scott when he was streaming, and he had to shut everything down and
It was on a
start up
monitor.
again.
It was on a monitor visible in the courtroom, so it was small, but it was there.
Yeah, and YouTube is sometimes really finicky about that stuff. I wish YouTube would recognize context a little better and be a little more forgiving, because like nobody is watching a court stream to see like a little square of porn in there to be like, ooh, okay, this is what gets me going. They're watching the court stream because it's court. And similarly, if somebody in like a court stream repeats the words, and the words are like, F U N word, and then YouTube is like, well, we're taking your stream down because that guy in court just said the N word. And it's like, dang it. So I wish that they'd be a little more forgiving of like context there, but
well, that's why
yeah.
the account manager wants to run ads in your channel needs to be contacted. Mine. I talked to mine like 2 weeks ago, and she said we want you to run ads on your channel as well. But have you thought about? And I said no one wants to run ads on a murder trial. I mean, who wants to be like, buy our candy and watch murder? No company really wants to do that. And she's like, have you thought about? We have these restricted content ads for gambling and alcohol. I said, have you heard of my channel name? I am a recovery addict. You want me to advertise gambling and alcohol on my channel? She's like, oh yeah, I see that's a problem. Anyway.
Yeah, they had that with me, and I was like, I'm okay with the alcohol ads, because if you drink in moderation, okay. But I was like, the gambling ads is not going to happen. And she's like, are you sure? I'm like, we're not doing the gambling ads, because in criminal defense, I've seen the alcoholics and I've seen the gamblers. And I can tell you, if I had to pick an addiction, I would pick the alcohol any day of the week, because the gamblers, I don't know what it is about the gambling, but it just wrecks people in a way that, like, it's incredible, like the degree that it goes to just wreck people. And I'm like, I don't want that for my I don't want that. So yeah, what I need to do is I need to find a way to get sponsored by like law firms here in Canada, but maybe I'll send out something going, hey, here's my you should sign up for this. So we'll see. But yeah. But all right. So Sarah Boon, opening statements. Mostly boring, other than I can't use any of my visual aids on the defense side and the prosecutor. You know what I think happened to the prosecutor? I think he wrote out and like rehearsed out a really good opening. Like not like an exceptional opening that just like wows you, but like a perfectly acceptable opening. And then he got through it. And then he looked at his watch and he went, I got 15 more minutes. And the smart thing to do, if you're a lawyer in this situation, if you've written out your opening and you get to the end of it, you've got 15 more minutes, is you say something along the lines of, thank you, ladies and gentlemen of the jury. You have a very difficult task ahead of you. We really appreciate your service. And we commend you for being here. I just ask, as the prosecution, all I really ask is that you pay attention to the evidence and that you make a decision using your faculties, using the instructions that'll be given to you by the court, and using the evidence you hear today. And then you sit down and you just burn those 15 minutes, because you do much better finishing quickly than you do talking forever. And one of the best closings I've ever seen was I watched a close from a very senior lawyer, and she just got up and she said, I have an hour to talk to you. I'm going to wrap this case up in 5 minutes. Said, you've heard a lot of things. The issue here today is whether or not, this person was the guy. And you need to focus on, and she just hit the critical pieces of evidence. And she said, you've heard a lot of evidence. This is the key to this case. And I ask you to think very hard about that as you consider the entire case. And she sits down. And she literally did it in 5 minutes. And the jury was out for like 20 minutes and came back with an acquittal. I was like,
it's a win.
It's a win. And it just shows, like, sometimes the best thing to do with your time is not talk. So I'm guessing that's what happened with the prosecutor. That's my bet. Now, can never be certain, but that was my bet.
If I can ask you a little bit about Boon here. Tomorrow, Sarah Boon's going to take the stand. The state's going to rest, and the prosecutors rest. The defense takes over. Defense has told our court watcher, Jules, that Mr. Owens went and told her that Sarah Boon's going to be my first witness, and she's going to be up first off the bat. I think they have to, so they can raise that whole the self-defense battered spouse syndrome thing.
Yeah.
Do you expect narrative form? I am pretty sure the lawyer doesn't want to be in the middle of this, right?
I don't think he's going to do narrative, but maybe. If he does narrative, they might as well just pack up and leave, because I don't think she can stay on a narrative if she had to. But and I mean, the jury may not know what narrative form testimony means, but we all know what narrative form means. It means she's lying, or at least that her lawyer thinks that she's going to be lying. And so But so I suspect he's going to ask her questions. I suspect it won't be narrative form, but here's my prediction. She gets up, she tells, her story. She talks about, how terrified she was of those two fingers coming out of the suitcase. And then they stop, they argue in front of the judge, and they say, "Hey, we think we've got self-defense, battered spouse on the table." And my bet is that the judge says, "You don't, though." And then that's it. They just have all of this stuff that they just
That's the
can't.
death knell. There's nothing else they have. If they can't get to battered spouse, it'll be the defense rests and goes to deliberation.
Yep. And one thing that you saw over and over and over again, with witness after witness, you saw the defense say, they'll ask like one or two questions, and then they're like, but subject to recall. And in every other trial that, LawTube has watched, very few witnesses, they say subject to recall. Most witnesses, it's just, you're done, go home, sir. But in this case, they've been saying subject to recall on most of the witnesses. In fact, it's just some of the police witnesses and some of the like experts and so forth that they've said, no, you're good. But everyone else, it's like, nope, subject to recall. And the recall is because it's like, after we get Sarah Boon to say, self-defense from the overt act of two fingers through the suitcase hole, then they're like, okay, now we want to bring all those witnesses in now that we've opened that, battered spouse and self-defense door. But I think the judge is probably just going to say, nope, I don't think you've got it. And if that's the case, then I don't know what they do other than just like pack up and I suspect
Sarah took the stand in a pretrial hearing, and she told her story. And the story was
bad.
It was terrible, and it was different than what she'd said before. But even that didn't meet the standard, so she has to take the stand and tell yet another story that will then meet that threshold for self-defense, which is, the prosecution is going to have a heyday. Just, which story should we compare it to? Which Sarah Boon should we believe? I can't see it happening.
And the thing is, the prosecution didn't really do a whole lot of cross-examination of her when she was, earlier. They, and that's largely because they just didn't have to. And they don't want to give her too much of a preview of the cross, right? They don't want to get her too, they don't want to prep her essentially for the cross in front of the jury. But in front of the jury, they're going to go to town on her. They're going to pull up every single, and there's just so many of these issues, and all of this is like pre-trial, but she, in her interviews, and this is again why you don't want to talk to the cops. Do not talk to the police, because everything she tells the police, like when she says, oh, it was a good day, I wasn't afraid of him, why would I do anything to him, it was such a good day. Well, then she gets up and she says, oh, well, I was so terrified of him that I had to kill him. And it's going to be like, well, were you lying then or are you lying now? Right? And
credibility's gone either way. So.
Yep. I think that even if it does go with a battered spouse to the jury, I think all it really does, it's basically like, imagine you're a baseball team and you're down like 40 runs. And suddenly somebody walks out and says, we can give you another 5 innings. And you're like, awesome. That's really going to be helpful, right? Extra innings, great. But we're so far behind, and they're going to be beating us at every, like, there's still that massive skill disparity. So how is this going to help? Right. Unless they're like, you get 5 extra innings and a shotgun that you're allowed to, shoot the opposing side with. Like, I don't see how this works out for them.
I think Sarah's best hope right now is that she has a Florida jury, and Florida juries have done some crazy things in years past, and maybe there's one. She only needs one. There's 6 people that can deliberate, and she just needs one.
She needs one who's willing to stand up to the others, which is tough. That's really tough. Because if I was on that jury, I could tell you that I would be just absolutely, like, I'm pretty sure that the jury right now, from where they sit, is sitting there going, can we wrap this up? Like, put her to the jail box, and then the rest, like, we have things to do. And they're going to listen to her, but the problem is that everything she says is going to be filtered through the context of the video of her laughing at him while he's in the suitcase, and his desperate, like, Sarah, I can't breathe. Sarah, please let me out. Sarah.
That's my name. Don't use it up. Yeah. Her response. Yeah. There were 2 jurors that were emotional watching that video, distraught, that our court watcher said, it affected them. And
I mean, absolutely.
And then they went to lunch. That's what they thought about all lunch long. I mean, that's
and that was on purpose. The prosecution's been running this really well. They don't ask stupid questions. There's none of that, like, is it snowing? Is it were there high tops? We got none of that. So all of that is it's not like the Karen Reed trial where every witness took hours because of that. And it's also not like, but he's also been planning things very carefully. Like that thing about, like, we're going to do the suitcase video and then lunch. And it's like, that wasn't an accident. That was entirely on purpose. And it's because he's just, he's the kind of good where it doesn't look effortful. It's the figure skater thing of, like, you watch a figure skater and you're just like, oh, I could do that. And then you get on the skates and you're like, I cannot do that.
Do you get the feel that this is personal between the prosecutor and Mr. Owens, between Jay and Mr. Owens? There seems to be, like, more tension between those two than normal.
I think not compared to some of the other trials. Like, if you watch the Karen Reed trial, they were at each other. If you watched even, like, the Gwyneth Paltrow trial, they didn't like each other. That was partially because Paltrow's lawyer is such an insufferable prick.
He's a bumbling fool lawyer. And I'm not sure how much of that is intentional. I mean, that takes us way back to Paltrow. That was a fun case,
but I think in this case, it's just that Owens is doing the best he can, and the prosecution is like, yeah, but no.
So today, Owens tried to bring in another witness, like Walker or something, to add him to the defense list, and it was going to be a Zoom witness. And Florida law says you can do it as long as both sides agree. And the prosecution's like, nope, we can't do that. We just can't. They can. If it was their witness, they could do it. They just know that the law's in their favor, and if they say no, it doesn't happen. It seemed like a petty move, but one they legally could make.
I mean, I don't know. Where I am, the prosecution would probably just consent. But U.S. lawyers do seem to be a little more cutthroat in criminal trials than Canadian prosecutors are. because I've had Canadian prosecutors basically, like I had a Canadian prosecutor who in trial basically made a motion to tender a piece of evidence, won the motion. So the against my objection, the evidence was going to go in, and then didn't tender it. And I went to the prosecutor afterwards. I was like, was that a mistake? And he's like, no, I thought about it a little bit more, and I do think it's actually too prejudicial. So I changed my mind. I didn't want to tender it. And it's like, the judge let him tender it. It would have been 100% fine with the judge would not have given him grief for tendering it. It wouldn't have caused a mistrial or anything like that. It's just the prosecutor was like, no, I don't think that this is in the keeping with a fair trial anymore. So
that's why we love Canada.
Yeah, and a friend of mine, I don't know if I should name him, but I will, Jared Moore. He was a prosecutor, and we had a contentious case. It was a case involving some police misconduct. And so we're there in court, and we're like, my friend's argument is completely illegitimate and, obviously wrong because of the following. And he'd stand up and he'd be like, well, what my friend is missing is and we were just at it. And then we lunch, and he's like, you want to go for lunch? And I'm like, yeah, I do actually. And so we went, and, after the trial ended, we went and, grabbed dinner, and we had beers, and it was like, because as much as the trial is contentious and as much as we're doing the sort of best to advocate for our respective positions, we also both recognize that, it's not that I hate him or anything. It's just I got to argue my thing. So I hope that's where they're at. I hope that they're just arguing everything as, as they can, and that they're, but I don't know. It's hard to say, right? I hope they're being chill and being friendly with each other.
Well, I missed the chat. Somebody said this has been going on for 4 years. He's just sick of this case. It's how long this is just stretched out.
Well, and the thing is I knew this case would be quick, so long as the prosecutor wasn't, wasn't lollying it up, right? And I think a lot of people in LawTube thought that this thing was going to last forever. And I'm like, no, it's, this is pretty open and shut. And there just isn't a whole lot of reason for the prosecution to stretch it out. I think that they want the jury to see a fairly punchy case that, open. They've got, so day one, they basically have, the neighbors saying they fight all the time. They're a bunch of drunks. They're, this, they're that. They start with the brother, and they start with the brother because the brother is going to get up on the stand and be sad. And I know that's a cynical, horrible way to say it and so forth, but it's absolutely the case, because it's what you do, right? You just say, look at this guy. He's the family member. He's really sad about what, about the loss of his, because you can do that. And it's not prejudicial. It's not improper, but it is prejudicial in the sense that, if you're a juror, what do you think when you see the brother crying on the stand or, upset in the stand? Yeah.
It hits you in the feels. You're like, man, this family, man, they're still grieving.
Absolutely. And Al Fliggins makes a good point, which is, in any other trial, this would allow the brother to sit in the gallery and watch the rest of the trial. But this isn't any other trial, because in this one, defense doesn't want to release him because defense is still hoping they get to argue the battered spouse, and then they want to bring him back so that they can say, isn't it true he totally beat up Sarah a bunch of times? And, that's what defense wants to do. And if I was defense, I would have let him go. I would have said, we're done with the brother. Because assuming that this is not BS, right? Assuming that she actually has been beat up by the guy and so forth, and she's got bruising and so forth to show. I want to get that in through any other witness that is not the brother. Because brother's going to fight you.
If they have to bring the brother back on the stand, they get double mileage from that witness because they're going to do the exact same thing they did at the beginning. And more so because you've got extra evidence, things you can question about, things that came up in court. And it's like getting a free lap around your opponent.
Well, and the thing is that the prosecution then gets to ask questions like if they recall him or if they call him on direct, then the prosecution gets to cross him, which would be even worse. But the prosecution is going to be able to get to, ask things like, which one do you think was the aggressor in their fights? What do you think the brother's going to say?
Not the 103-pound, 5'2" guy.
Yep. And I mean, she's just the brother will 100% say, no, it was Sarah was the aggressor the whole time. And, every single time they had a fight, it was because Sarah started it. And so, I mean, that's the last witness I want to bring back to try to make that point. I don't know. And Elfliggins again makes a solid point. Elfliggins is a lawyer, so good, good sense there on that. But that maybe keeping him under subpoena just so that he can't be sitting there glaring at Sarah because Sarah won't be able to. She can't keep her powder dry,
or keep her face towards the front of the court either. She's been flipping around, looking at everybody, grinning, looking, smiling.
I mean,
she even got sort of told she was not supposed to do that anymore. But
she, what I think she's thinking right now? I think she's thinking that when all of this is done, she's going to start up a podcast. She's going to maybe start an OnlyFans, and I'm not judging on OnlyFans. It's just, it's a popular way to monetize popularity. Start a YouTube channel, start whatever. And, I think she thinks that this is her big break. And, I think she thinks she's going to walk. I think she thinks she's going to, and I don't know. I think it's going to be really, really difficult for her when at the end of the day she's convicted, because I expect that's where she's going.
She'd say, but it wasn't intentional, not intentional. Just like she did in her interview. That she thinks that if people would just listen to those words, that it was not intentional, it would change the facts. And the intentionality was there. It's the first step she took going upstairs was intentional. It wasn't laying down on the bed and falling asleep. It was when she walked away from that suitcase, assuming you throw out all the video. But when she walked away, that was intent.
The thing is the other thing on this is she didn't have to get convicted here because she had a path to acquittal on this that she just walked away from in the biggest way. So, as an example, if she hadn't videotaped her whole thing, she'd be way ahead of where she is right now. If she just never videotaped it. If she never videotaped it, and she never talked to the police, I could win this one. And I don't think it would be hard.
It puts it back in the realm of a whodunit instead of why, Sarah, why?
I mean, that's the thing, is you just get the court on the, like, you get the thing up on the stand. She doesn't testify. She just sits there the whole time. She doesn't say anything. And the defense lawyer can say, how do we know how we got into that suitcase? Because they were both drinking heavily. Maybe, there's a text about hide and seek. Maybe she went and, was in the, she went and passed out, and he found a great hiding spot, and she got tired of looking for him and decided to go to bed. Like, hey, come on out. Where are you? Okay. If you're not coming out, fuck you. I'm going to bed. You can come to bed when you're feeling, when you're feeling a little more, whatever. And then just the next morning, she just like, oh, how did I find him? Well, because, he died and there was a smell and so forth. Prove it wasn't that. Prove it wasn't that she zipped him up in there, and then because she'd had an entire giant-sized bottle of wine, passed out, and then woke up and was like, oh, shit, right? Because that's the thing. If she zipped him up in there and was going to unzip him, then, then all of that is, like, fine. And it's like, how does he end up at the bottom of the suitcase? Well, he's in a suitcase. He's trying to get out. He rolls himself down the stairs. Somebody says, how did he zip himself in? Prove he didn't, beyond a reasonable doubt. And, all of these things are possible, but she's eliminated so many of those by talking to the police. And you might say that's great because, she did it. She should go to jail. But the thing is that also works perfectly well on innocent people. Innocent people get themselves into this trouble too. Because even if you're innocent, you talk to them. What's a great example here is, you go to visit a friend. Like, a friend calls you and basically says, hey, I owe you a lot of money. I can't pay you. Can you come over and we talk about other ways to work this out? And you're like, okay, fine. I'll go over there. We'll talk about it, but I want my money. And you go there and you find out that someone else has kicked in his door and shot him. And so you call the police, and the police show up, and they're like, what do the police think in that case? Well, obviously they think you shot him because there's a text saying, hey, there's a debt. You went over there. That's what they think. And you go up and you say, I didn't shoot him. Wasn't my gun. I didn't shoot him. I don't know any of this. They will use it against you that you said you didn't do it when their theory is that you did. It's like, well, obviously he's lying because he shot him. And it's like, they'll bootstrap it up that way.
About 20 years ago, I made a mistake. I talked to the police. I'll tell you the story sometime, but I found a bomb. I had nothing to do with it. But I found a bomb, and then I called the police, and I spent many hours in a police station Christmas morning being interrogated by a single cop who was both good cop and bad cop, which is a funny story because he had to play both roles. I almost, the ATF got involved, almost wanted to press charges against me because I hadn't called soon enough or something. It was wild, but yeah.
You're like, how was I supposed to supposed to call you earlier?
I'm the good guy here. I did not do it. But yeah, I'll tell you the story sometime.
What was the guy who called in the bomb at was it the Olympics or something? And then they decided it was him, and they ruined his life. And Um,
And then it wasn't.
and then it wasn't him. He was just like guy who was just trying to do the right thing. Yeah, it that that kind of thing happens. Richard Jewell, yeah, at the Atlanta Olympics. So, that ruined his life. And then you're sitting there going, well, how is that fair? I had a client whose name got broadcast in the local newspaper because he got charged with a sex offense for basically woman at party who was passed out in a bed. He found her there and was like, you should not be passed out at this party. Took her, picked her up, took her to her house, and basically set her down in her bed, waited until he was sure she wasn't going to stop breathing, and then left and dropped the keys through the mail slot. She wakes up the next day and she discovers that she's been assaulted, and they get DNA and so forth. But she says, I have a vague memory. And she's, she was drugged. She says, I have a memory of this guy on top of me. And he's like, well, of course she does if she's got a memory of that, because he was picking her up and moving her. So anyway, he, against my advice, provides a DNA sample, because my advice was basically do not provide a DNA sample. It's totally going to convict you, because I'm assuming he's probably done it, because usually that's the case. But he provides a sample, and it comes back as totally not this guy. It's someone else. And, his thing of I'm taking her home is super believable, because he told several people that he was doing so. He got her purse, he got, her ID to get her, her location, he got her keys. So for all indications, basically this guy saw somebody who was vulnerable and was like, you need to be safe. And
but got run through the paper, and
they broadcast his name as offender. They didn't even broadcast, they didn't publish that the charges were dropped.
No retraction, nothing.
No retraction, nothing. Just so if you search his name online, you find charged with sex offense.
Oh man.
And the guy's actually got a letter from the prosecutor that basically says, didn't do it. We the wrong person was wrong person was arrested.
But unless he used that as his cover sheet on his resume, I mean,
but that's the problem. He still can't get employed, because you can't even
you can't make it to the interview.
You can't make it to the interview. You submit your resume, and the thing is even if you're coming in with I've got a letter of I was wrongfully charged, they don't want to they don't want to take the chance on that. So it's absolutely wrecked his life. And it's just that police involvement. And I mean, in his case, he gave a full statement to the police, which turned out to be word for word true, and it didn't stop them from charging him. So
terrible. So
yep,
keep your lips zipped.
And I mean, in his case, he probably would have ended up, because she remembered and she knew who he was, so she would have. But I've seen people charged for they report a break and enter, and the police are like, well, this place was broken into, and the only person we know of who was in the area was you. So it's
must be Occam's razor. Yes.
That's crazy. It's really awful sometimes where you've got those kinds of circumstances. But let's see, what else does the prosecution have? They've got the positional asphyxia from the from the coroner, from the autopsy. They've got her text messages with the hide and seek and so forth. And the big thing is they got the video. They've got the video.
Her own words. And just the stark contrast between what she said and how she said it, the fact she was intoxicated, and then her statement to the police, which doesn't match up any of that before she knew the video existed. It looks like a still frame when they turned that video and showed her, look what we found on your phone, and she just froze and just like stares at it and just it's trying to does not compute. How do I handle this? It looks like she's just frozen in place.
Well, the other
Sarah.
The other really bad problem she's got, like absolutely awful problem she's got to work with on all of this, is how does she deal with the way she looks manipulative, the way she looks super, super manipulative on all of this, because you can see her basically saying things like, what do I have to say to get you to stop charging me? It's like she looks like she's how do I put this in a way that is not going to be offensive?
There isn't a way, you just have to say it.
All right. She's a dumb person who hangs out with other dumb people. And she's used to being able to manipulate dumb or sympathetic people. And what I mean by that is that she's used to dealing with people who will give her an out. And she's asking the police to give her the out. The problem is the police have no interest in giving her the out. The police have the interest in exactly the opposite of that. So when she says things like, well, what do I need to say? The police are like, well, you could just confess. That would be awesome.
Only at the end of her interview did she start to be worried about what she had said. And she's like, well, I didn't confess. she's trying to convince them that she hadn't just told them everything they needed to arrest her and prosecute this case. I didn't confess.
The thing, she's not used to the this is what I mean by, like, she's a dumb person who hangs out with other dumb people. She's not used to people who can catch her on those things. And she's not, I feel like she's the kind of not that smart person who also hangs out, like, who basically would cut somebody out of her circle of friends if they were smarter than she was. It's just to be like, I need to be the smartest person in the room, which means it's got to be a very depressing room. That's kind of how she does her manipulation. And the problem is, if you've got people who are a little bit smarter, and when you've got it recorded, it's really transparent and really, and it's sad, right? It's just like, now I don't think she thought he was going to die, but I don't think she cared a lot, too much about whether it happened. That's kind of my thinking on that, is I think she just figured he'd probably get out, but if he didn't, fuck him, kind of thing. And, yeah, the other one I was surprised by, Elf Liggins here with the, is her ex. I liked her ex. Her ex was actually a reasonable person. Like, her ex is like, they're like, why were you calling her all this? And it's like, well, because she's supposed to pick him up. Like, she's supposed to pick up the kids. She's real bad at picking up the kids, which is also not going to be great for the jury to be like, oh, she doesn't really love her kids. That's that's really sympathetic. But he was like, he was reasonable. He was not crazy. Like, and you know, when it's like, oh yeah, I saw his feet, and I was like, I ain't going in there.
I'm done.
What did you think about her? Oh,
go ahead.
What did you think about her trying to get the ex-husband into the apartment?
The fact that she called him after unzipping George, basically, he's probably, you know, a little bit of rigor mortis in fetal position, and she calls him. Was she asking for help? Like, what do I do now that doesn't involve the police? And the husband didn't respond the way she wanted, and now she's like, oh crap, now I better call the police and we'll figure it out from there.
I think she was hoping he would try to like step in and do body cleanup for her.
Oh my goodness.
And I think that her backup plan on that was that if he doesn't do the body cleanup, that maybe she could blame him.
Ooh. Wow.
Like, I think Buddy not stepping in that room
was
the smartest. Because, you know, could you imagine he comes in, he puts his fingerprints on everything, and what she's going to say? She's going to say, oh, yeah, my ex came over and, you know, they got into a fight and, you know, one thing leads to another. And so now the chat is saying that you look exhausted. You've been at this for forever. Are you being too polite to...
This last weekend, I went down to South Carolina and helped with the Hurricane Milton cleanup. So I've been running chainsaw for 2 days, Saturday and Sunday, and I hurt in places I didn't know I had. I have not been doing that sort of manual labor in a long time. It was a lot of fun. Great to help out down there. The 7 hours of driving back and forth just about killed me. So I'm a little bit tired. I don't normally have the black circles under my eyes like this. So I probably do have to call it a night and get some sleep. But,
well, thank you so much for joining me and for sharing that. That is an amazing and crazy story, but it is, and the thing is that's actually a story that I may end up citing because I, at some point, want to try to get like cameras in the courtroom here and just being like, listen, cameras in the courtroom may have actually solved a murder.
If I can help in any way, I'd love it because I cannot wait to watch Canadian courts. Not just the accents, but that level of politeness in the courtroom. That's going to be amazing. I can't wait.
I actually think I would love to be able to cover a Canadian trial and just to be like, listen, you know, look at these two. Look at these two who are being respectful and whatever else, because the judge will shut you down if you start being shitty to the other side in court. I would love to be able to do that. But, and also just to be like, all these Canadians think that they've got like First Amendment rights or Second Amendment rights or, you know, and it's like, no, you've got charter rights, which are similar but different. And they don't understand that like Canadian procedure is different in some ways than American procedure. But yeah, I would love to be able to do that. I just need to find a trial that'll let me cover it. And what I may ask to do is to say like, listen, can I do coverage where I get the feed, I record my my video, and I'll do like a week-long trial of me recording, and then I'll just hand it over to the court, and the court can redact whatever needs redacting. And the court can say, yeah, we really don't like this witness's face being on there. Please remove that. Or, you know, whatever else. But at the end of the day, like still, you know, put something out there that people could see, or just like, yeah, this witness, that should go. And then we could say like, listen, we'll release this after the jury verdict, right? The jury has come to a decision. It can't possibly interfere with the trial, but at least people could watch a Canadian trial and see what was going on and see what that was about. I kind of also just want to cover one that's not like a Canadian trial, that's not like a murder or a big sex offense or whatever, but just like guy steals bottle of liquor from liquor store. Because that's the average trial. Like that's the average ordinary course of business of the courts. And yet nobody knows what that looks like. But Canadian courts are just allergic to televising. The only court in Canada that televises regularly is the Supreme Court of Canada. And I just want to be like, well, if we have the if the Supreme Court can do it, why can't you?
Yeah.
So
maybe one day you can crack that open. That would be amazing. I would. If
I'm
there's
gonna
anything
work
I can
on
do
it.
to help. I mean, if cameras, you tell me, set up, I can help you out on that front. So
I may do that, but I'm gonna let you sleep. If you're heading back to do Milton stuff, let me know if there's anything I can do to provide support there as well. Because yeah.
Well, the guys in Asheville, North Carolina, that was the area that got where the towns to the bridge just washed away. Around that area. I was going by their base. I had my ham radio on. I was listening to their call at the end of the day, and they just said, "Look, if you show up here with any more water, so help me, we're gonna fire shots over your head. We don't need water. We need kerosene. We need containers for kerosene. We need carbon monoxide sensors. We need warm clothes because winter's coming and stuff like that." But it's gonna be months for most cleanup, and unfortunately, some towns just aren't coming back. They're gone. So it's heartbreaking, but appreciate that.
Yeah.
Let me know when you're doing your thing as well.
November 2nd is the big day. I'll be going 24 hours, so I'll send you a link and you can pop in and pop out as you wish, because 24 hours is crazy. I don't expect anybody to be there for the whole time, but it'd be awesome if you can hang out for some of that. So
I'd be honored. Thank you very much, Ian. It's always great to hang out with you. You got a great group here, so thanks for the invite.
Thank you, and likewise. We got to do this more often. But guys, check him out, Recovery Addict. He does great coverage, great commentary, and I'm going to kick him off now so that he can go get some sleep. Good night. See ya. All right, so that's kind of the Boon trial. I don't know what else there is to say about it. I did say I'd predict the future. So we're going to predict the future. So here's what's going to happen tomorrow. Prosecution's going to close its case. Prosecution is going to finish its case, and then Boon is going to get up on the stand. And Boon is going to be awful. She's going to be a gong show. She's going to go through and she is going to do her absolute best to paint herself as a victim, and it's going to look super transparent. The problem that she has is that anything she says that is helpful to her will contradict other things. So they're really going to focus on the two finger. Oh God, that gesture looks awful. I just saw the gesture on that, and that just looks awful. So they're really going to try to focus on the all of the that is the overt act. And I think the judge ultimately is going to say, listen, we don't think that this is ultimately, I don't think the judge is going to say that they think that the overt act is sufficient. And I think then the case wraps up pretty quickly. I think the case is going to be over and done. I think by the end of the week. So I think I didn't want to cover this case because I think it's kind of boring. I think it's kind of boring because I think that there's no suspense to this case. It's no like, oh, what's going to happen? Like, oh my God, will she be convicted or won't she be convicted? I think that you can send the jury into the I think that you could send the jury into the jury room and then start cooking a pizza for that jury, and they'll probably be done before the pizza's ready. So, and Elf Liggins is saying, I think the 2 fingers are enough of a scintilla that the judge will err on the side of appeal protection. Maybe. I think it's possible. I don't know. I think this judge might have the courage to just say, I don't think it's there. And I don't think he'd get overturned on appeal. So, yeah. And somebody says, it wasn't too boring for Ian to watch EDB's stream. I was watching EDB's stream because A, I like watching EDB's commentary. B, I like hanging out in the chat. I just think that the case itself is kind of now I might. So tomorrow, I work. I got to work, right? So I can't do a live stream as it's happening. Tomorrow is also date night. And I'm just going to say I made a rule some time ago that was basically I am going to take date night seriously. Date night matters. I'm not going to fuck around on date night. So I'm going to do date night. But Mrs. Runkle is probably going to be turning in early. So I'll probably, what I might do is depending on how long Boon testifies, I might do a Boon testimony like review tomorrow night, late night, or I might do it Wednesday night. So we'll see. We'll see. All right, chat. I saw a request for the Bederow letter. We can do that because we got a bunch of stuff to cover, and as usual, I am behind because my whole thing of like I'm not going to take too long on this. I'm like I suck at that. It is just not my skill set to be to be quick. Oh, yes, let's cover super chats. Rainman YYC, thank you for the 5 gifted memberships. Much appreciated. Mispronounced name. A wild Scot appeared. Quick, throw a Pokeball. We like our free range, Scott. I talk about Bruno. Hello, Runkle and Bonus Recovery Addict. Hello, I talk about Bruno. Legally Blonde. What a treat. My 2 faves on one stream. Awesome. Fat Yoga, love seeing you both. I will pass all of these along to him later on. He's got to sleep. Katrina Turner, I think one lawyer in a hot tub ruined it already. I don't know if it was the hot tub that caused the problems there. Thilo Agthe says Runkle's audio and video slightly desynced. And then a bunch of other people said they didn't have that problem, but I don't know how to fix it if it is. So K-Dubs, thank you for the membership there. Joy W101, thank you for the 5 gifted memberships. Jada Jur, thank you for 10 gifted memberships. XCDA, thank you for 10 gifted memberships. Much appreciated. Lauren, RA, show Ian about the judge watching you. That'll have to, I will make a note. I'm going to ask him about that. And I'm going to, we're going to do that. So I'll get that story at some point. Mostly Harmless Fuzzball, thank you for the YouTube membership. I love the username. Dr. Science for Ian's Xbox Trophy Fund. Thank you. Sandy, thank you for the 10 gifted memberships. Much appreciated. Laura Christine, thank you for the 10 gifted memberships. Jackie Lindy, good news in the Tyron McAlpin story. Maricopa DA decided not to die on that hill and folded to public pressure. Charges are dismissed in that case. I don't know if he's going to sue the Phoenix PD. I'm kind of torn on that one because I can see some of the things on that. Deb Vitz has just got back from picking up from friends from the airport. That's nice. Is Andrea Burkhart inbound? No, Andrea's gone to bed. We're covering Andrea's filing, but I don't expect Andrea to be here. She's got to sleep. Yellow Pill NP. It drives me crazy that YouTube doesn't take context into account with words because using watered down terms for serious topics feels borderline disrespectful sometimes. Cheese pizza, unlived, etc. Yep. Chris A, thank you for the YouTube membership. Much appreciated. Canonical Heat, thank you for the 20 gifted memberships. Canonical Heat says, appreciate the mods, do the things, donate to Extra Life. Thank you so much, Canonical Heat. CS Tears, member longer because new YouTube account. Fair enough. I wish there was a way to like restore that, but Laura Annie, brief recap of Scott's disaster relief weekend, please. I think we had that. Thank you, Laura Annie. Much appreciated. Kaylee, hubby and I tested zipped suitcase. I lasted 30 seconds. You are braver than I am because, yeah, against the tide. Please like to help with Ian's pro bono goals. Laura Annie, thank you for the 5 gifted memberships. By the way, there was a bit of a hilarious moment in the interview, like the interrogation. In the interrogation, she talks about zipping him up in the suitcase, the hide and seek, and what is it? And the officer is like, so is that like foreplay for you guys? And I was like, yeah, that's a level of kink that no thanks. Sean Wilson, thank you for the new membership. Jaded Jur, you're a great guest, Scott. Thanks for the video you provide and for visiting us. I'll make sure I'll pass these along. Laura Riker, she looked like a deer in the headlights. Sarah, yep. She was real bad. Becca has thoughts. She thought her ex was going to help her fix it. I think she did. And I think that she thought, I think she would have put it on him if she thought she could. One Crazy Cat live stream tomorrow. And how would you frame battered spouse with how aggressive she comes across in the interview? I mean, she's going to lose on the battered spouse. I will see about a live stream. If I do, it'll be real late. Mackenzie Jabali, what about a mini series to start with as a trial run for Canadian court? What I'll probably try to do as a trial run for Canadian court is, so what I need to do, is I need to get my income here up enough to the point where I can quit my day job. Because if I can quit my day job, one of the things I will do first and foremost is I'm going to find a big Canadian trial and I'm going to cover it Andrea Burkhart style, where I'm going to say, where I'm going to go to the trial that we can't televise, and I'm going to take notes, and I'm going to do a recap later, and I'll be like, okay, we had this witness, and they said this, and we had this witness, and they said that, and here's what's going on, and, so that's what I'm going to try to do. Mildred Katie, case is more train wreck than interesting. Yeah. The other thing is I feel like a certain amount of it is making fun of Sarah Boon and like her mental health or her intellectual deficiencies. So yeah. How is your shorthand? It is god awful. I have dysgraphia. Relia says, how much wood would Chuck Norris chuck if Chuck Norris were to chuck wood? Trick question. Chuck Norris would not. He'd tell it to go chuck itself. Equality. What? That clickbait. Lol. Regarding Andrea. I did clarify. I was trying to say we're going over her filings. KLM, will we be getting a live reaction to the new letter? I haven't read it yet. I intentionally set it for a live reaction. So good question. And yep. Linda Santiago, love Monday nights with you. I love spending Monday nights with you guys. Michael J. Money, hate ads, but pro bono goal is way too important. I'd struggle through all the ads for it. Here's a couple dollars to help you out since you turned them off. The deciding factor on the ads was the people saying, I can't hear the story because the ads are interrupting it, right? The ads are fucking with your story. So yeah. Apple Silver says, did you email your lawyers yet? I emailed one of them. I have to do the other one. So Jagaz mom, my son has dysgraphia. So many people have no idea what it even is. I had a laptop throughout high school because of dysgraphia. All right. So now we're going to go through the most recent letter. This is from October 17th from Mark Bederow. Now, this is with regards to the case of Adrian Carney, also known as Turtle Boy. Turtle Boy is a blogger and a journalist He actually does better journalism than... Oh, I'm being told I got to swoop. I will swoop. I'll swoop sort of mid-explanation. Swoop. So Turtle Boy does better journalism than most journalists, like most people whose job is journalist. The problem is that Turtle Boy does it in a fashion that is a little bit aggressive, a little bit boisterous, a little bit... he pisses some people off. So because of that, they decided to... Aidan Carney has been charged with witness intimidation. Now, the witness intimidation statute in Massachusetts is so broad that if you hiccup, you basically have committed witness intimidation in Massachusetts. And somebody's saying, now I need to know what dysgraphia is. Dysgraphia is a disorder of handwriting. Dysgraphia basically prevents people from, yeah. So, by the way, also on the ads, I will have ads turned on after the stream, but I'm just going to keep no ads during it. So dysgraphia is a disorder of handwriting. It means that your handwriting is slow and usually ugly. And in many cases, including mine, it can be actually painful to handwrite. Dysgraphia is, one of my sort of neurospiciness. Somebody says, I can't tolerate Turtle Boy, not because of his content, but how he delivers it. He's too rude. That's the thing. He is, he doesn't make friends, and he doesn't care about making friends. So, but that said, the charges against Turtle Boy appear to be a little bit bullshit. And what I mean by that is that the charges against Turtle Boy seem to have been arranged by a sort of an angry person who basically set him up to be subject to this. So let's we've reviewed some of the previous letters, and let's go through this most recent letter, because these letters are really really spicy, and they are identifying a lot of potential issues. Okay, we are going to put me there. We're going to embiggen a little bit further. Okay, hopefully people can read. So, Law Office of Mark A. Bederow, PC. So, via email to Robert Cosgrove, Special Assistant District Attorney. It says, Dear Mr. Cosgrove, we are scheduled to appear in the Norfolk County Superior Court on December 2nd, 2024, to address issues related to the Commonwealth search of Aidan Carney's cellular phones. To date, the defense has not been provided with any data or extraction reports from Mr. Carney's devices, which have remained in the Commonwealth's possession since the Massachusetts State Police seized them on October 1st, 2023. All right, that's already fucked up, because they really should have turned all of that over, right? They really should have turned all of that over. For approximately 1 year, the Commonwealth has claimed or implied that Mr. Carney's cellular phones have not been searched. These representations are patently false. Norfolk County District Attorney Michael Morrissey and Special Assistant District Attorney Kenneth Mello have known since October 2023 that MSP Detective Lieutenant DL Brian Tully searched Mr. Carney's cellular phones, and that MSP extracted at least one of them prior to October 31st, 2023. So, we recently came into possession of several pages from a Celebrite extraction report of Mr. Carney's cellular phone. How did they come into possession of them when the state is saying they don't exist? Whew. Ha 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 ha. and proof that it was searched by D.L. Tully in October 2023 during an investigation orchestrated by D.A. Morrissey into alleged witness intimidation of Chris Albert and Jennifer McCabe by a Stoughton court clerk and Mr. Carney. It is outrageous that the defense obtained evidence in your actual possession related to alleged intimidation of named witnesses in the indictments against Mr. Carney from a third party rather than from the Commonwealth, who was obligated to disclose this evidence to the defense several months ago, but instead has repeatedly denied its existence. Ha ha ha. Yeah. I was not pronouncing it correctly before, but somebody corrected me, so yeah. This is some incredible fuckery. This is some incredible shit here. Because the prosecution has an obligation, if they've got evidence in their possession, they're required to turn it over. This is basic shit. This is 8 o'clock day one prosecutor shit, right? You need to turn over the evidence in your possession. It is so obvious that this appears in My Cousin Vinny as a way to illustrate how dumb Vinny is, or at least how new and how unaware of what the fuck he's doing Vinny is. So, yeah. D.A. Morrissey launched the investigation, which relied upon the MSP's search of Mr. Carney's cellular phones on September 29th, 2023, Exhibit B. This was after he engaged Mr. Mello to handle any investigations involving Mr. Carney due to a conflict that arose after Mr. Carney's dogged reporting exposed information that persuaded a large segment of the public that the Norfolk County DA's office and MSP framed Karen Reed for the murder of John O'Keefe, which almost overnight created the worldwide Free Karen Reed movement. Okay. Now they note the Celebrate report identifies the owner of the extracted Apple device as Clarence Woods Emerson, which is a pseudonym used by Mr. Carney on Facebook. Despite similar, lots of people on Facebook use fake names. Yeah. Despite similar, if not worse, conflicts with Mr. Carney, the Norfolk County MSP Homicide Unit has not recused itself. D.L. Tully is leading an investigation in which his two direct subordinates, Trooper Micah Proctor and Sergeant Yuri, interesting nickname, are alleged victims of Mr. Carney. D.L. Tully and Trooper Proctor are presently under MSP internal affairs investigation, and Sergeant Buchanan already has been disciplined for their inappropriate conduct in the Reed case, which bolsters the credibility of Mr. Carney's reporting on the Reed case. This obvious conflict, combined with the Norfolk County MSP Homicide Unit's exploitation of the Massachusetts witness intimidation statute by utilizing it in favor of witnesses who despise Mr. Carney and refusing to employ it against those who are aligned with Mr. Carney and/or are critical of the Reed case, exposes the unit's animus towards Mr. Carney and creates the appearance of an improper motive for investigating him. This is really well written and it's really punchy, and I just love this. As D.A. Morrissey recognized in recusing his office, public confidence in the MSP and the Norfolk County criminal justice system, which currently is dreadful in large part due to the MSP Norfolk County Homicides Unit's conduct in Mr. Carney's cases, the Reed case, including Trooper Proctor's suspension without pay for his shocking and disgraceful treatment of Ms. Reed, and the flawed Sandra Birchmore investigation. Ooh, they're bringing all the things in. Compels that the Norfolk MSP Homicide Unit be replaced with unbiased investigators from another county. Now, the problem is that the unbiased investigators are still going to be police, and they're still going to be probably inclined to go with the police. Nice. I love the writing here. Lest there be any doubt that Mr. Mello didn't know in October 2023 that Mr. Carney's phones were searched and at least one extracted, his failed attempt to indict Karen Reid and Mr. Carney for conspiracy to commit witness intimidation shortly before Ms. Reid's trial, in which Mr. Mello elicited testimony from D.L. Tully that he searched Mr. Carney's cellular phones in October 2023, settles that question. Oh, ho, ho. So basically, he's saying, you not only did you fail to turn this over, but you knew. And I have the receipts. The receipts are in the transcripts. You can't wiggle out of this shit. We are deeply troubled by Mr. Mello's misleading representations, which have left the court and defense with the false impression that Mr. Carney's devices have not been searched. And the thing is, if you're not going to search Mr. Carney's devices, then just don't fucking seize them. Or return the devices if you're not searching them, right? It's like either search them or give them back. Why are you hanging on to them? Put simply, it is undeniable that the Commonwealth has failed to disclose any evidence from Mr. Carney's devices, despite Mr. Mello's, D.L. Tully's, and D.A. Morrissey's knowledge for more than 1 year that such evidence has been in the Commonwealth's possession, and that at least one of Mr. Carney's cellular phones has been extracted. By the way, when he says at least one, it's both. There is no way they failed to extract the other one. To be clear, we do not believe that Mr. Cosgrove has deliberately made inaccurate representations to the court and/or defense. Rather, it appears that D.A. Morrissey, Mr. Mello, and D.L. Tully have failed to inform him about the true circumstances surrounding the searches and extraction of Mr. Carney's cellular phones. Okay, so they're like, this, we don't say you're up to malfeasance. We're not saying you're up to no good. But we're saying they're lying to you. Yeah. Oof. So Mr. Mello has certified that his services as a special assistant district attorney incurred as of September 20th, 2023. Morrissey officially authorized Mr. Mello's engagement on September 26, 2023. Thus, D.A. Morrissey agreed and understood prior to September 29, 2023, that Mr. Mello was the proper official to handle investigations related to Mr. Carney's alleged intimidation of witnesses in the Reid case. On September 28, 2023, Chris Albert, man, this is the most incestuous freaking case ever. Most incestuous case ever. So yeah. Everybody is connected to everybody, and yeah. Chris Albert, a witness in the Reid case and an alleged victim in the 2023 indictment, sought but was denied a protective order against Mr. Carney before Judge Daniel O'Malley of the Stoughton District Court. I hope I'm pronouncing that right. Every time I say Stoughton, somebody says nope, or Stoughton. So yeah. Of the Stoughton District Court. This application was heard and decided in a courtroom open to the public. Later that day, Mr. Carney published a blog about this matter. Stoughton. Okay. That evening, Jennifer McCabe, another witness in the Reid case and an alleged victim in the 2023 indictment, complained in a text message to an unnamed individual, "I know it's late, but I'm horrified that Chris didn't get it. And I'm even more disgusted that for the second time, someone from the court leaked it right away to TB." And I'm pretty sure it refers to the protection order. And TB doesn't refer to tuberculosis. It refers to Turtle Boy. Although if you asked Jennifer McCabe which she'd rather hang out with, she might pick tuberculosis. They're not fans. So, Ms. McCabe's message was forwarded to D.A. Morrissey, who included it in an email he sent the following day to Stacey Fortes, Chief Justice of the District Court, Thomas Ambrosino, Massachusetts Trial Court Administrator, Philip McHugh, Deputy Court Administrator, Judge O'Malley, First District of the Stoughton District Court, or Stoughton District Court. I don't know. I'm just going to keep getting that wrong. And Lynn Belland, Norfolk County First District Attorney. I don't know if she's actually a Belland or not. So on May 30th, Ms. McCabe unsuccessfully sought a protective order against Mr. Kearney in the Stoughton District Court. This application was also decided in a courtroom open to the public. All right. D.A. Morrissey used a personal email account. Oh, interesting. Is he dodging discovery? Is he dodging that's real interesting. This is the kind of thing, by the way, when you see that like personal email account, it's like, oh, you're up to some shit, aren't you? You're up to some shit. So D.A. Morrissey used a personal email account to communicate with numerous high-ranking court officers. Why would he be doing that? I don't see a good reason for it, but including the judge who denied Mr. Albert's application for protective order about official business he described as a matter of grave concern. Someone in the Stoughton District Court shared an affidavit that was prepared by a witness in the Commonwealth versus Reed murder case. And he misspelled Reed. Stoughton. Or Stoughton? I don't know. Without elaboration, D.A. Morrissey named court employee Michelle Littlefield as the leading suspect. He expressed concern that the Reed case witnesses had lost faith in the courts and that the actions erode the trust and integrity between the courts and the public and the relationship. Oh, fuck. Guys, the irony meter has just gone up to 11. The irony meter has just like gone up to 11 and broken. The Reed case witnesses had lost faith in the courts and that the actions erode the trust and integrity between the courts and the public and the relationship with the district attorney's office. We are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage to witnesses in an ongoing homicide prosecution, must be a violation of court policies or a potential violations of law. Potential violations. Okay. We also understand that Aidan Carney has also immediately requested copies of the FTR record that was made on September 28th, 2023. Again, there's no way that he would have or should have known that a hearing took place. Unless he did like a journalism. It's possible that he did a journalism and found stuff out. Because like that's the whole point of doing a journalism, is that you know things that people would like you to keep quiet. He might have done a journalism, folks. So they note email addresses used by employees of the Norfolk DA's office end in mass.gov. The email address used by D.A. Morrissey for a September 29th message ended in at iCloud.com, which is associated with an individual's personal Apple account. I'm also just going to say Bederow is a nicer man than I am. You know why he's a nicer man than I am? Because if I was Bederow, and I am not always a nice man, if I was Bederow, I might have gone ahead and said, I'm just gonna put the email addresses in the filing. I might have just put the email addresses in the filing, and then Morrissey would have had to change his personal email address, because I'm guessing that if his personal email address made it into a publicly filed letter, that some people would email him, and yeah. Not anyone from this chat, of course. You should not email him if you're here, but yeah. All right. That same day, Catherine Peter, an MSP source against Mr. Carney, see October 8th letter, tweeted that Mr. Carney would be arrested on October 10th. He was arrested on October 11th. On an October 3rd Facebook post, Ms. Peter publicly identified Ms. Littlefield as the target of the unpublicized investigation, posted her picture, and announced that Ms. Littlefield had been suspended as part of the investigation. Oh, whoa. So she's getting a fair bit of information back. So DA Morrissey concluded by demanding that these matters be resolved immediately and that he would await your advice. Which means basically do it fucking now. So after Mr. Carney's October 11th, 2023 arrest, his cellular phones were seized and maintained by Tully. At approximately 9:15 a.m., the MSP obtained Mr. Carney's passcode and gained access to them. Within 1 hour, Ms. Peters sent a childish and harassing direct message on Twitter and X to one of Ms. Reed's attorneys. It says, "We know you're involved in Aidan Carney's little witness harassment game, and your texts with him have already been making the rounds. Buckle up, Buttercup." Okay, that's interesting. So footnotes, transmissions from 7:53 a.m. on the day of Mr. Carney's arrest confirm that MSP officials assigned to arrest Mr. Carney, including Tully, heard from KP, but it was the same thing yesterday. 2 older kids getting on around the same time, but it was 8:30. Mr. Carney was arrested at 8:34 a.m., 1 minute after his children boarded a school bus. Remarkably, it appears that Ms. Peter participated in the MSP's apprehension of Mr. Carney by surveilling him at their behest. Now, this is really interesting, because if she is surveilling, at their behest, then she's gone beyond just a witness, right? Because at the point where you're sitting there saying, that now you're acting on behalf of the government, you are now a state actor. And so, for example, let's put it this way. And I'm going to use a Canadian example, but the rules for all of this are the same shit, right? Let's say my client is beaten up by a cop, right? The cop arrests him, and in the course of arresting him, just starts beating the shit out of my client. I could apply for a stay of proceedings based on that action by the government. They're not allowed to beat the shit out of him. But let's say instead of the government beating the shit out of my client, it's like the store owner, right? My guy steals a bottle of liquor from the store, and the store owner beats the shit out of him, right? I can't apply for a stay of proceedings based on the government action there, right? Because the store owner isn't a government official. He's just some random dude. He's just some random Joe Schmo, right? And so I don't get those protections, like my client doesn't get those protections against the government if it's just some random Joe Schmo. But let's put an additional wrinkle on this. Let's say the guy arrests, the store owner arrests my client. He ties him up. He's waiting for the cops, and he calls the cops and says, "Hey, I got this guy." And the cop says, "You know what? This guy's going to get bail. He's a repeat offender. If you could just hit him with a bat a few times and maybe like lock him in a suitcase and then hit him with a bat a few more times, that'd be really awesome. Like, we'd really appreciate that. And then the guy does. Well, now he's acting on behalf of the government. He's a state actor. And his actions at that point implicate the government. I'm back into being able to ask for a stay of proceedings where the case gets thrown out based on that use of force. Once somebody is a state actor, they're held to the same rules, right? And the reason why is because you can't use, the government can't use like patsies. They can't just pull somebody else in order to violate your rights, right? Okay, proceeding on here. So Tully has testified that he viewed text messages between Mr. Carney and Ms. Reed's attorney is on Mr. Carney's cellular phone. They shouldn't be looking, well, no, I guess there wouldn't be privilege there. Okay. Ms. Peters' baseless implications that Ms. Reed's attorney engaged in witness intimidation is another example of her pattern of engaging in violation of witness intimidation. Why? Because everybody in pardon me, everybody in Massachusetts is guilty of witness intimidation. It's just, that's how broad that particular statute is. So, Law Office of Mark A. Bederow, PC. So, on October 31st, 2023, Stoughton District Court Clerk Lauren Green presented Ms. Littlefield with evidence gathered during the investigation demanded by D.A. Morrissey. These materials included copies of D.A. Morrissey's September 29th, 2023 email and several pages from a Celebrite extraction report from one of the cellular phones seized from Mr. Carney on October 11th, 2023. See Exhibit A. Mr. Mello's misleading assertions about Mr. Carney's devices. So, I got hair in my mouth. That's not fun. On October 19th, 2023, Mr. Mello emailed co-counsel Timothy Brattle that he did not know how far the MSP had progressed in any review of Mr. Carney's devices. So clearly, if he doesn't know how far they've progressed, he knows that they have at least progressed somewhat. A few hours later, after speaking with Tully, Mr. Mello updated Mr. Brattle. Tully is the only individual in possession of the electronic seized, and I can confirm that he will cease any further searches until this matter can be addressed by the court. You have my word on this as an officer of the court. By the way, off like that, when you say you have my word on this as an officer of the court, this is basically the lawyer equivalent of slapping your testicles on the table. Because if you say that you are giving your word as an officer of the court, and it turns out you are full of shit, that basically triggers consequences. You are potentially at risk of the court reaching over with a great big hammer and giving those balls a tap. Because, you have my word on this as an officer of the court. If you are using your status as an officer of the court to lie, you can be sanctioned. Somebody says, play the bonk sound, Ian. Give me a second. I can try to play the bonk sound. There's the bonk sound. All right. From October 20th to November 8th, 2023, Mr. Brattle asked Mr. Mello 3 times if Mr. Carney's phones had been imaged, which would have made it unnecessary for the Commonwealth to maintain possession of them. Mr. Mello tellingly ignored these inquiries. He doesn't say no. That's a problem. Also, I'm not getting as much signal as I want. I'm going to shut off my VPN. All right, VPN active again. Here we go. Or sorry, internet active again. On November 16th, 2023, Mr. Mello reassured Mr. Brattle Mr. Carney's devices had not been searched. I gave you my representation that we would not examine the contents of the electronic devices without sufficient prior notice to you. Please know that we obtained search warrants this morning for the contents of said devices. I have asked Tully and he has agreed to refrain from executing said warrants. Your client's devices will not be examined prior to the court's ruling on your motion. Ooh. If they're lying about this to counsel, this motion, how do I put this? If I'm reading this motion and I am, if I'm Mellow and I'm reading this letter, I am taking this letter as seriously as the sound of like a hammer clicking backwards, like clicking back in the darkness, right? This, or a rattlesnake's rattle. This is really one of those moments where you're like, oh shit, I'm in danger. Yeah, this is, I love the writing because it's very polite. It's very, it's very dignified, but it's definitely it's definitely hearing the slide getting pulled back and you're like, oh shit. So, yeah. The pages of the extraction report provided to Ms. Littlefield omitted a May 30th, 2023 message in which Mr. Carney was told that a local reporter observed the proceedings where Ms. McCabe was denied a protective order against Mr. Carney. Interesting. Also, is this the first time they say the extraction report provided to Ms. Littlefield? Okay. On November 28th, 2023, at a hearing in the Stoughton District Court, which I'm probably still getting wrong, Mr. Mello couldn't have been any clearer in representing that Mr. Carney's devices had not been searched. He said, the state police and the investigators have not perused the material. It is in pristine form located on the defendant's devices. That might be some very careful fudging by them. That might be some very careful fudging because it might be that they're saying, oh, they haven't looked at it. They imaged it, but they haven't looked at it. And it's still on the defendant's devices, but we're just not mentioning that it's also somewhere else. That might be very careful, clever omission. I don't know. The court then asked if Mr. Brattle if he'd been advised by the government that they hadn't started the search, that there's been no search done. Mr. Brattle indicated that it was his understanding that no search had occurred. Instead of clarifying the obvious misimpression that the court and Mr. Brattle believed Mr. Carney's devices had not been searched, Mr. Mello merely replied, we would not investigate. We would honor our commitment to further not investigate until this matter is determined by the Superior Court. Oh, it sounds to me like he's weaseling real hard on this, right? This to me sounds like he knew exactly what the hell was going on, but that he was very, very carefully avoiding. He's choosing his words really super carefully and just to like create an impression. And yeah. By the way, this kind of lying by careful omission is not something the court will put up with. You can't go to the court and be like, Sure, I just intentionally entertained a misconception in your head, but everything I said was strictly true by the most like literal direct meaning. This should be getting some serious punishment. Mr. Mello further stated that if he provided the devices to the defense, Mr. Carney might delete data and thereby impair the integrity of a later extraction. Oh, which is implying that you haven't done an extraction. In other words, Mr. Mello gave the court and defense, and they note here, the defense has not been provided with these warrants or underlying affidavits. We demand immediate production of these documents. And video of this proceeding is available at chat. We're not doing it tonight. We're not doing it tonight, but we gotta watch this video, don't we? We gotta watch this video. That's gonna have to be another live stream because we pretty much have to. All right. So in other words, Mr. Mello gave the court and defense the clear impression that Mr. Carney's phones had not been searched or imaged for extraction when he knew the exact opposite was true. See Exhibit A, testimony of Tully. It strains credulity that Mr. Mello, who frequently discussed the investigation with Tully, didn't know on October 20th, 2023, that Tully had, in fact, searched Mr. Carney's devices and that at least one phone had previously been extracted. Mr. Mello's misleading representations and failure to disclose evidence that he was obligated to provide to the defense several months ago likely violate the rules of court and the rules of the Massachusetts Rules of Professional Conduct. I am loving this. For more than 1 year, the Commonwealth has steadfastly refused to return Mr. Carney's devices. Even worse, you haven't disclosed to the defense any evidence contained therein. Instead, the Commonwealth has repeatedly maintained that Mr. Carney's devices have not been searched. The Commonwealth's obfuscation has harmed Mr. Carney professionally, and it has prejudiced him as a criminal defendant. He's entitled to data on his phones that is necessary for him to continue his journalism, and he has an absolute right to review evidence to which he is legally entitled. And the thing is, if they're trying to do this to prevent him from engaging in journalism, then we also have a First Amendment issue here, right? Because if they're trying to use these criminal processes to stop journalism, that is fundamentally the utter core of the First Amendment, right? Like the First Amendment protects your right to be an asshole. It protects your right to do things like, the First Amendment protects your right to go on Twitter and say something like, Donald Trump or Kamala Harris, whichever one you prefer, has a tiny penis, because that one's insulting to whichever one you say it to. So, you've got a right to do that, but that's not really the fundamental core of what the First Amendment is intended for. I mean, it's under that, but it's not like the fundamental issue, right? Being able to say that how was it put? The basic atom of the First Amendment is the right to say, fuck the government. But more than that, it is really a big deal as to which journalism was really one of the things that they were very much aimed at, because they wanted to, this is back from the era where they had newspapers and so forth who were, critical of the government. So, yeah. So, given irrefutable proof that Mr. Mello and Tully, and almost certainly D.A. Morrissey, have known that Mr. Carney's devices were searched and at least one extracted in October 2023, the Commonwealth's failure to disclose any evidence recovered from Mr. Carney's devices and any extraction reports from his cellular phones is indefensible, a clear violation of his due process rights to access material evidence and a fully prepared defense. Because, of course, some of the texts on that might actually be, like, critical to his defense. So, footnotes, Mr. Mello's dubious representations are another topic that we intend to examine him and Tully under oath in support of our pending motion to disqualify Mr. Mello under the rules of the Massachusetts Rule of Criminal Procedure. And on April 23rd, 2024, Mr. Mello was ordered to disclose by May 8th any evidence in his possession that was subject to automatic disclosure under Rule 14. And if he hasn't, and if he's violating a direct court order, man, the thing is, we've seen Carrie Morrissey write like 50 pages of absolute utter bullshit that is long-winded and, you know, all of this. But instead, what we have here is, what we end up with is this filing by Mr. Bederow is concise, and it is like, it's like a landmine field that is just all mines. It is packed with goodness, right? It is just lovely how many different nasty things they talk about here and how many bombs they're dropping. Because it's just like, this is all bombs all the time, folks. So yeah, I'm loving this. The defense believes that Mr. Carney is being prosecuted to stifle his First Amendment rights. I think they believe that because it's because it's real obvious. I don't think it's a nuke. I think this one is a cluster bomb. I think this one is a cluster bomb because there's just so many little explosives in it. And at the end of it, it just, yeah. So is being prosecuted to stifle his First Amendment rights to report and opine publicly. I wonder why they could possibly believe that. Publicly and loudly about alleged corruption and misconduct in the Reed case by the Commonwealth, MSP, and civilians who are now witnesses against him. We further allege that the MSP wanted to seize Mr. Carney's cellular phones to improperly access his sources of knowledge about the Reed case and to review any information he possessed regarding a federal investigation into their conduct during the Reed investigation and prosecution. Which is also a First Amendment issue. So, accordingly, pursuant to Brady, Graham, and Rule 14, we demand any investigation or any information and evidence in your possession, custody, or control regarding the seizure, search, and extraction of Mr. Carney's devices, including but not limited to true, accurate, and complete copies of any data searched and/or observed, any extraction reports, search warrants, affidavits in support of search warrants, when the devices were searched and extracted, by whom, any reports, email, documentation in any form, describing the contents, searches, or extractions of the devices, or communications between and among, or to and from, Morrissey, Mello, Tully, anyone associated with Norfolk DA's office or MSP, any of the individuals referenced in DA Morrissey's September email, Ms. Littlefield, Ms. Green, any other employees of the Stoughton, I don't know. I'm just going to give up on that because every time I say it, somebody in chat is like, no, you got it wrong. Jennifer McCabe, Chris Albert, and Ms. Peter. I was like, are they going to leave Ms. Peter? No, they are not. We look forward to your prompt disclosure of the requested evidence and any other required Brady and Giglio disclosures that result from your discussions with DA Morrissey, Mr. Mello, Tully, or any other appropriate individuals regarding the issues we have raised about Mr. Carney's cellular phones. Respectfully, Mark A. Bederow. And the thing is he is actually being respectful. Because he could be a lot meaner. He could be a lot meaner on this. All right, so we got Celebrate. Participants, Scott Rodriguez, I don't know who that is, and Clarence Wood Emerson, owner. Conversation, instant message. Some of these are hard to read, folks. So system message, you can now read messages and call one another. Source info. From Scott, it says, yeah. From Scott, did you get a copy of the affidavit? Attachments, which we're not going to be able to read what those are because really small font. Response, oh, wow, how'd you get this? I believe the proper term is sources. Lol, I have some friends that work over there that are Turtle Riders. Turtle Riders, by the way, is his is like Turtle Boy's fan group, right? So yeah. Awesome. Thanks, man. And then more attachments. This was denied. And then Turtle Boy responds with GTFO. How'd you find out? And then have a friend in Stoughton Court. Stoughton Court? Okay. Oh my God, this is gold. Thank you. And then more attachments. I know a tough ask, and if I wasn't worried for my friend, I wouldn't even ask. But could that be edited to credit Mass Courts instead of Stoughton? What's it? It's not on Mass Courts. And then more attachments. That's not her, is it? Okay, so that's what we've got. And then Exhibit B from Michael Morrissey to Stacy Fortes, Thomas G. Ambrosino, Philip J. And they edited out Morrissey's email address. They edited it out because they're being nice to him. You know, when Bederow is a nicer Bederow is a nicer man than any of the people he's dealing with. So, dear Judge Fortes, I am writing to express my grave concern with actions taken by an individual employed at the Stoughton District in regard to an affidavit that was shared with a blogger writing about an ongoing second-degree murder case. On September 28th, a witness in the Commonwealth v. Reed, spelled wrong, murder case, filed a request for an application for harassment prevention order, which was heard before Judge O'Malley. The application and affidavit were processed in the Civil Clerk Department of Stoughton District Court and presented to the judge, which, after hearing, was denied. We were informed by the witness and others that shortly after the hearing that Aidan Carney, a.k.a. Turtle Boy, was provided with a copy of the entire affidavit. There's no way that he would have been aware of the proceedings without an insider working in the courthouse. The leading individual who presents as a possible leak is Michelle Littlefield. Now, I think they just outed Michelle Littlefield in this because they did say received from Littlefield. So, yeah. The one they accused of being a whistleblower is innocent, by the way. She was not the leak. Okay. I know it's late, but I'm horrified that Chris didn't get it. And I'm even more disgusted that for the second time, someone from the court leaked it right away to Turtle Boy. Then, because the people who work in Stoughton District Court like me more than him, they sent this humiliating affidavit to me. That would have been affidavit to me, so we could shame him some more. We've put in a request for the court audio, and hopefully, with a little luck, we'll have it for the live show on Sunday. So, that would have been... This would be Turtle Boy saying that. All right. The above comments from a previous witness are also received the same treatment with their application for an HPO is attached. Also, the comments from Clarence Woods Emerson, aka Turtle Boy, are attached. It is clear from the postings that Stoughton Court is directly involved in this dissemination of information affecting our murder prosecution. From the comments from one of the witnesses, you can see that they have completely lost all confidence in the courts of the Commonwealth. Again, this is super ironic because tons of people who are watching all of this have lost all confidence in the courts of the Commonwealth because of Mr. Morrissey and this stupid prosecution against, against Karen Reid and Turtle Boy now. So, I have to agree that the actions erode the trust and integrity between the courts and the public and the relationship with the district attorney's office. We are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage to a witness in an ongoing homicide prosecution, must be a violation of court policies or a potential violation of law. We also understand that Aidan Carney has also immediately requested copies of the FDR record that was made on September 28th, 2023. Again, there's no way that he would have or should have known that the hearing took place. Again, unless he did a journalism. So, yeah. After David is an in-joke. Okay, fair enough. I am not on the Turtle Rider mailing list. But I support, fairness. There are a number of concerns that we would have about the possibility of having file ongoing motions or other requests for warrants before this court that will affect the orderly and fair administration of justice. These actions are completely unacceptable and must be resolved immediately. I understand that you have to do an investigation and that may take some time, but you also have to provide us with some evidence and assurance that you've taken action so we can safely continue to use the clerk's office of the Stoughton District Court. We have a number of delicate matters before them on a day-to-day basis. I await your advice. Michael W. Morrissey, District Attorney. Then we go on to Exhibit C, which is the standard contract form. All right, so this is Mr. Mello's. This is Mr. Mello getting hired. Okay, we don't care about that. Exhibit D from Margaret Krippendorf regarding Special District Attorney. FYI, we'll be preparing an electronic contract for below. Still a few days out, but wanted you to be aware. Thanks, Deb. And then the response, or there's approved. His rate, so they're hiring Mr. Mello. Mr. Mello's rate, was $400 per hour. Huh. I'll address this here. I find a lot of Runkle stories unbelievable. Really? Really? Because, are you not seeing the shit that happens all the time in court? My stories are fucking tame, dude. Compared to this, compared to like Karen Reid, compared to any of this, come on, man. His rate is $400 per hour. I put the maximum obligation amount at $30,000. Please let me know if you think this amount should be adjusted. I'm gonna guarantee that it went up. Also note we can adjust or increase moving forward as well. So he's getting $400 per hour. Charlene says, what is the clicking? I will stop playing with the thing. Exhibit E, mass hole report. This lovely lady is Michelle Littlefield. If you're down at Stoughton District Court, you can rest easy. Your personal information is safe for the time being, as she was perp walked out today and put on suspension pending an internal investigation. What is it that Karens like to say? You work for me? Well, Michelle, you fucking scumbag, you work for us. And your decision to share sensitive information entrusted to you through the court to further harass and stalk a civilian really caught up quick. Trust and believe it's going to follow you around too. You'll be getting more attention soon, as will our new friend Janelle. I hope both your careers were worth it. Wow, that seems like intimidation of a justice system participant. Wow. Exhibit F. Masshole Mafia. We know you're involved in Aiden Carney's little witness and harassment game, and your texts with him have already been making the rounds. Buckle up, Buttercup. Smiley face emoji. Oh, wow. All right. So, I'm just going to say Bederow comes out swinging. He really doesn't mess around. That is a whole other, that's a whole thing. I love his writing. I love his yeah, and that seems to be threatening Karen Reed's attorneys. Apparently that was sent to Yannetti. So yeah. All right. So let's that's just astounding, right? That's just freaking astounding. Wow. I am a huge fan of Bederow, I gotta say, because like, this is excellent writing. This is just the kind of writing that you just want to see out of a lawyer. It is really clear, it's concise, and it's a bomb in every paragraph, right? Every single paragraph, he's got a new bomb to drop. So that is just amazing. He is, and yeah. Now the next one, I couldn't find my redacted version, so I gotta take a second to redact. But we'll talk as I redact here, because I what is it? We're going to look at Garth Brooks. Garth Brooks went a little nuclear on this one, and I'm going to try not to go as nuclear as Garth Brooks did. I'm going to try not to do that, but we're going to point out just how nuclear she went. Because, yeah, we're just going to redact out some we're just going to redact out some faces. We're going to redact out some things. And yeah, let's let's cover some super chats here as well. I'm just now you guys have probably seen the name. You guys have probably seen the name online and so forth, but I don't feel the need to repeat it because her allegations, even though I find her allegations to be incredibly implausible, her allegations are of sexual assault, fairly serious sexual assault, if you believe them. So we're just going to do a little bit of censorship here to remove some of this, and yeah. Because what was filed includes a lot of things like email addresses and phone numbers and so forth. I might not censor it perfectly. There might be a name that slips through, but we're going to try. I think I've got them all. The problem is that this is not searchable, so I can't just do a find and replace. So yeah, we're just going to censor as much as we can to try to cover all of this. Have I got all of this? All right, I think I've got all of this for the first document here. All right, so we're going to apply our redactions. Where's my apply button? There's the apply button. Apply. So we're just going to do that. All right. Let's cover some super chats here. Morgan says, I wish there was support for lesser disabilities when I was in school. I have severe ET. ET, I don't know what ET is. And writing was torture. I physically can't write now. Yeah, writing was torture for me too. I was glad when they let me use a keyboard. Equality, thank you for the 5 gifted memberships. Much appreciated. Morgan, ET is essential tremor. There we go. I finally had brain surgery to install a computer to control it. Very simplified, of course. Now I get periodic hardware upgrades. Morgan, can I just say how cool it is that you are a cyborg? Can I say how amazing that is that you are a cyborg? Boss Attorney Bree, hey everyone. Good to see you, Bree. Bree, November 2nd, I am doing a 24-hour live stream. You are welcome to join us. I will send you a link. You can pop in and pop out whenever you'd like. We're also going to be doing a Hot Ones challenge for that. So if you wanted, you could pick that up and join for that. Yeah, November 2nd, we'll be doing it'll have a charity auction. It'll have me getting stupid as I run for 24 hours without sleep. Maggie says, like tomorrow? No, November 2nd. It's like, it's little less than 2 weeks. So, yeah. Morgan, that is super cool that you are a cyborg. Furious says, Morrissey, it is way too comfortable sending that email. It's clearly not the first time. Yeah. Jackie Lindy, if you did post the email, I'm too lazy to email. Fair. Jeremy Morton, towards viewers being able to hear stories instead of ads. By the way, I find the Boon case boring too. I'm glad I'm not the only one. Amanda Lang says, did you hear about the gallery member signaling the not a friend paramedic during testimony in the Karen Reed trial? On video, woman in white beside O'Keefe's. I did not hear about that. Aurelia says, you remember in high school when crowds would gather and shout, fight, 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 fight? I feel like we just sat here reading that letter. You're not wrong. Rain Man YYC, so Norse scrotum whipping. I hope that's not a Norse thing. Tough Cookies, thank you for the 10 gifted memberships. Laura Leanne, thank you for the 5 gifted memberships. Marielle says, it's been suggested Reed was to avoid Freedom of Information Act searches. Interesting, maybe. GP Dog Drool, Mello built $80,000 after that $30,000 contract. Jesus, I'm not surprised, but I'm horrified. Phoebe Bird, I'm excited to hear you shred the DA's actions to shreds. To shreds, you say? Yeah, that is really what that's what Bederow's doing. So yeah, okay, let's do a swoop. Swoopity swoop. Swoop. All right, so we got the swoopity swoop, and so now let's talk about Garth Brooks. I feel like Garth Brooks is a good one to talk about here today. So I'm just wanting to, and this one requires more censorship. More censorship. Why? Oh, is this the same document? It is, because I ordered the same document twice. That's the memorandum. No. That's one of two. There, I didn't open the same document twice. I just screwed up in opening the all right. We're just going to do a redact. We're going to find text and redact. We're just gonna quickly we're going to, let's see, how do I, all right, we're going to redact those. We're going to do a new search. We're going to search for this. Search and remove. We're going to redact all of those, and we're going to do a new search for this. And we're going to select all, which is, there we go, check all. And we're going to mark all that for redaction. There we go. Now, do I need to redact anything else in this one? Nope, this one's much easier. Okay, that's done. We're going to apply. We're going to go. I redacted them, and then I forgot where I saved them, and they weren't where I usually save things, so I just didn't have them. So Sarah says that I'm leaving. It triggered. We're not going to go through any of the allegations. There's no this is just fighting over revealing names. So the Garth Brooks thing is an issue of sexual assault allegations. But what's happened in the Garth Brooks litigation? So Garth Brooks started basically the plaintiff or the defendant, depending on which side you're on. She threatened to sue Garth Brooks, so he sued her first, and he sued her first under the under the name of John Doe versus Jane Roe. So, he sued and he kept everyone's names quiet. The other side was like, we want to reveal all of the names. And then they basically went ahead and filed in California and put Garth Brooks' name out in public on purpose. So what has Garth Brooks done? Well, Garth Brooks then refiled his lawsuit. He's like, okay, I consent to, I consent to the issue. And then he refiled his lawsuit with her name publicly visible. So, we're going to go over what he did, because this might be a little bit of shit here. And what is it? I just missed one redaction, so we're just applying one more redaction. I just noticed it right afterwards, and it's like, oh, right, that's just right there. All right. So, all right. So let's embiggen this. Plaintiff's response in opposition to defendant's motion for emergency sealing or redactions and for sanctions. So plaintiff Garth Brooks submits this response in opposition to defendant blank's motion for emergency sealing or redaction and for sanctions, and would show that the motion be denied. In support, Mr. Brooks relies on the attached evidentiary materials and the arguments and authorities set forth in his accompanying memorandum in opposition to this motion. And KLM says, Beland quit and Tully rehomed after this letter Friday. Yeah, he's doing some damage. So, why do you use John Doe rather than Chris Gaines? Because John Doe is how you file it anonymously. So, and I see Peppermint says, Garth Brooks held a restaurant door open for me once in the north end of Boston. Lol. I can tell you, Garth Brooks has never done anything for me. I don't even listen to his music. I don't think I could even name a song of his. I know last time I said that, some people were like, here are songs of his, and I've forgotten them all. So Garth Brooks has never done anything for me ever. Garth Brooks has never done anything for me ever. June says, will EDB join you on this November 2nd for your broadcast? She's invited. It's up to her as to whether or not she wants to. That's up to her. So, but she is invited. So, all right. So, yeah. And I know somebody out there is going to be like, you're just a Garth Brooks simp. And I'm like, I don't even like country. um, like, I don't like country. I don't know Garth Brooks. He's never done anything for me. I get nothing out of this other than just you guys watch it. So, yeah. So let's look at what he's filed here. So, article Heritage and Culture Made in Mississippi, from country music to wedding bells. And I just want to note here, that big blacked out thing is a photograph. This article that was filed here has a big photograph of the complainant there. So, yeah, and then there's more photographs, including apparently of her wedding day. So, yeah. These are pictures, by the way, of Nicole Kidman, but her picture was front and center. So, stylist to the stars, hair and makeup. A wedding is your red carpet moment. Let us make it unforgettable. So, blank is a leading celebrity makeup artist, esthetician, and groomer. Groomer has become a bad word. Groomer has become a bad word. Lawyer You Know is also invited. I think Lawyer You Know is going to pop in. So, known to create picture-perfect looks for clientele such as Nicole Kidman, Keith Urban, Nikki Taylor, Eric Church, Trisha Yearwood, Vince Gill, Garth Brooks, Lionel Richie, and many others. Having spent much of her career focused on the needs of celebrity clients, Ms. Blank delivers a level of trust and service that encourages confidence from her famous clients. Blank is now based in Madison, Mississippi, delivering the same quality of service that has made her the most sought-after stylist by the biggest stars in the entertainment business. Why are they filing this? Well, I would have filed this with some redactions. I would have filed this with her face covered. I would have covered that up. But the reason why he's filing this is to show that she already, by filing her lawsuit and by indicating that she was his hairstylist and so forth, that putting that together with her public statements already revealed her identity, right? You already tip your identity off to everybody. Therefore, you don't have an anything. So, let's see what they have to say. So, plaintiff's memorandum in opposition to defendant's motion for emergency sealing or redaction /for sanctions. So, defendant blank already agreed to use her name in this litigation. She also included so many identifying details in her California lawsuit that it eliminated any possibility of her remaining anonymous in this Mississippi case. Her sudden about-face to now protest plaintiff's filing of an amended complaint identifying both parties rings hollow. Garth Brooks filed this action as John Doe versus Jane Roe on September 13, 2024. He concurrently sought leave for both parties to proceed under pseudonyms and to file any personally identifying exhibits under seal or with redactions. Mr. Brooks did so to protect both parties' identities and to spare both parties' families the repercussions of Ms. Blank's false allegations. So you see what he's trying to say here is he's trying to say, listen, I was looking out for everybody. I was looking out for everybody. But here's the thing. Let's just do some math on this. Let's say Garth Brooks had filed as John Doe versus her specific name. That also would have revealed his name real freaking fast, right? Real fast, his name would have been out there. So, yeah. Rather than accept Mr. Brooks's offer, Ms. Blank opposed Mr. Brooks's motion for joint pseudonymity in its entirety. This was a fuck up by her lawyers, because her lawyers, what they should have done is they should have said, we are opposed to Mr. Brooks remaining anonymous, but we support Ms. Blank remaining anonymous, right? The other thing that they should have done is that they absolutely 100% should have filed at the same time. At the same time, they should have filed their own application for pseudonymity for, for Jane Roe, right? They should have filed that themselves. Their lawyer fucked up. Their lawyer screwed this up badly. And it's a whole thing, right? So she should be pretty pissed at her lawyer. So she did not move herself to proceed under a pseudonym. Instead, her opposition to Mr. Brooks's motion called pseudonymity a drastic exception to the rules and pressed the court to hold that allowing parties to proceed under a pseudonym is the exception, not the rule. Now, I think that this is a little shading things, because it was pretty clear from their filing that they wanted to expose Brooks, but not her, right? So Ms. Blanks further argued that the courts may not seal information merely because it could lead to a litigant's embarrassment, and that vague assertions of harm to reputation are not enough to strip the public of its right to know the identities of litigants. Ms. Blank even urged the court that both parties to this case should proceed under their own names. She wrote that no basis under Fifth Circuit law exists to grant Mr. Doe's request to seal the record or redact publicly filed documents to conceal the identities of he and Ms. Roe. Whoops. Unless there be any doubt about her willingness to identify herself, Ms. Blank added that she's willing to proceed using her name here if this court believes that it is necessary in denying plaintiff's motion. Now, I saw some comments here that I do want to address. I'm not sure Garth is Jane's only male client, but I'm guessing Garth is Jane's only male client who had the specific shows that Jane identified. Like, she identified specific shows that he was performing at and specific things to honor the person at. So it would have, that would have been enough to reveal. Please remove it's not allowed. I haven't actually seen the infamous glasses in her pictures. They aren't in the pictures, though not convinced the hairstylist thing reliably identifies her. Combined with the other information in her lawsuit, I think it does. I think it does, because she identifies like specific dates when she was. So, yeah. The court should deny defendant's request to seal the amended complaint. First, the court should take Ms. Blank at her word and deny her emergency request to seal the record, redact her name, and award sanctions against Mr. Brooks or his counsel. So next, the court should deny defendant's request to seal the amended complaint. No law, statute, or rule obligated Mr. Brooks to file his original complaint or his amended complaint under with pseudonyms or under seal. He initially used pseudonyms for both parties in his original complaint and immediately moved for leave for both parties to proceed under pseudonyms in an effort to protect both parties and their families from any harm resulting from public disclosure of Ms. Blank's attempted extortion of Mr. Brooks. Ms. Blank could have embraced the opportunity to remain anonymous. She chose not to. Instead, Ms. Blank opposed Mr. Brooks' motion, declaring that no basis under Fifth Circuit law exists to grant Mr. Doe's request to seal the record or redact publicly filed documents to conceal the identities of he and Mrs. Roe. And there's some footnotes. We're going to go through some footnotes because I love footnotes. Footnotes are my favorite thing. Footnotes are delightful. The other thing I'm just going to note here is that Ms. Rowe is going to have a very hard time arguing the sanctions on with regards to the issue of hey, he filed on his own with her real name, when that was exactly the tactic that they used against him. So Kimchi says, I mean, Joe Public isn't usually going to know who the hairstylist was for an artist on Date. No. If you searched Garth Brooks and hairstylist, you would have found her name. And her name is not hard to find. I had her name before it was publicly filed, right? It was not hard to find at all. And so it was like super easy. So yeah. The news would have found her name and the news could have reported it. So yeah. Misty Grace says, can chat quickly tell me what is she's accusing him of? I missed part of this. She's accusing him of non-consensual sex. And she is very, very specific about like the position and so forth. The problem is that her very specific description of the position, I don't know how that works in like three-dimensional space, because I just don't see how it's possible. I don't see how it's possible for the arrangement of bodies that she describes. So, yeah. So, read most generously, defendant's opposition indicated she would prefer to proceed under a pseudonym, but she did not file a motion for pseudonymity. She absolutely should have filed that motion. 100% she should have. Like her lawyer fucked up here, right? Really, really, really fucked up. And yeah, this is the other problem is her lawsuit reads like bad airport smut. Yeah, it really reads like shitty online fan fiction, right? Like shitty / fiction. So, yeah. So, so they note any written communication with the court that is intended to be an application for relief or other action by this court must be presented by a motion in the form prescribed by this rule. And they note a response to a motion may not include a counter motion in the same document. Any motion must be an item docketed separately from a response. So what they're saying is you never had your own motion. And until you have your own motion, you don't get to, you don't get to complain. So let me put it this way. Let's say there's a gate and I want that gate to be kept closed, right? And I see that my neighbor has put a padlock on the gate. And I go, cool, no one's going through that gate, right? No one's going through the gate. My neighbor put a padlock on it. Excellent. No problem. Well, what's the issue with that? Well, the issue is that my neighbor can take the padlock off anytime he wants, right? He can just walk up and be like, no padlock no more. And then I'm stuck going, oh, there's all sorts of people coming through my gate because I didn't lock it. If I want the gate locked, I need to put my own padlock on it. Similarly, if she wanted her, her pseudonymity, she needed to also file her own motion for that. Because otherwise, Otherwise, Garth Brooks can be like, yeah, I've abandoned the motion. We're filing without seal, which is exactly what happened. So Ms. Blank's admission precludes her as a matter of law from arguing now that her identity should be concealed. See the matter of BVS construction. Concession by BVS's counsel at hearing constituted a judicial admission and as such is binding on BVS, i.e. when she says that she's okay releasing her name, that's binding on her and not in a good way. So, yeah. Ms. Blank's emergency motion is also procedurally defective because she did not file a supporting memorandum brief as a separate docket item from her motion, as required by the rules, but instead submitted a letter brief as an attachment to her motion. This is also a reason to deny her motion. Yeah, they're not going to deny her motion on that basis. So, yeah. Aeon X has a good question here. Just out of curiosity, is his wife sticking by him? Yes. She went on Instagram and she basically posted something that was very clearly supportive. So Ms. Blank then mooted Mr. Brooks' motion before the court could consider it. She did so by filing a California lawsuit that named Mr. Brooks as the defendant and, even before her complaint was available on the public docket, widely disseminating her unfiled California complaint to media contacts. The California lawsuit not only identified Mr. Brooks, but disclosed Ms. Blank's identity as well, i.e., they're saying you already gave up anonymity by your filing of the lawsuit. In her complaint, she describes herself as a Mississippian with a 30-plus year career who has worked as a trusted makeup artist and hairstylist to Mr. Brooks and his wife, Trisha Yearwood. She goes on to add that she has performed the hairstyling and makeup for celebrities appearing in countless publications and has received numerous credits on advertising campaigns involving top celebrities and brands and for her work in television commercials and film. As internet sleuths and country music industry insiders discussing this case online announced weeks ago, the California plaintiff can be only one Mississippi citizen. Blank. Leaving no doubt, Ms. Blank in 2022 touted her professional relationship with Mr. Brooks and Ms. Yearwood in publications such as Mississippi Magazine, with a photo of the three of them together that Ms. Blank apparently provided, and on social media to generate business in Mississippi. See Exhibits 1 and 2. So, basically what he's saying here is your own complaint filed, revealed all of the information. And because your own complaint revealed all of the information, you don't get to complain that we revealed your identity because you revealed your identity. And you know what? I think he makes a good point here because the internet sleuthed this out in like 0 seconds. I saw all the gossip pages when I was doing some research trying to figure all this out. When I saw all of the gossip pages, they had figured out her name so fucking fast. The news had broken like 2 hours earlier, and all of the gossip pages had figured her name out. So how can... And the thing is that's also on her freaking lawyer. Like, I'm careful about, like, where I live. And I'm careful enough about it that sometimes I make little fibs about where I live. So, for instance, I might be like, hey, I went to this restaurant that's right near my house. And it might be, or it might not be, because I just kind of don't want people finding my house. I'll go and intentionally drive like across town to take a picture in a park rather than like walking to the nearest park, where I am. And I don't even know where the nearest park is, but I'll intentionally drive to another place so that I can be like, okay, because that way, if somebody online goes and figures out, hey, here's where this park is, they can't like draw a circle around that to find my nearest thing. And wait, though, didn't you dox yourself recently? I did accidentally hold up a piece of mail with my address, and then that video got blurred out. So, yeah. But basically, they're saying she revealed the information already. So, Mr. Brooks filed his amended complaint identifying both parties only after Ms. Blank, 1, opposed his motion for pseudonymity, and 2, publicly outed herself, both herself and Mr. Brooks, through the filing of the detailed California complaint. Mr. Brooks's amended complaint does not plead a rape or a sexual assault case, factors that might justify anonymity. It alleges that Mr. Brooks is the victim of Ms. Blank's attempted extortion, defamation, false light invasion of privacy, and intentional infliction of emotional distress through outrageous conduct, including the publication and threatened wider publication of false allegations of sexual misconduct that would irreparably harm plaintiff's reputation, family, career, and livelihood. By the way, like, she has harmed his career, right? She has harmed his career. So, nor does Mr. Brooks' amended complaint contain any lewd or graphic or sexually explicit information concerning Ms. Blank that justifies an order sealing it. By contrast, her complaint gets really lewd or graphic or sexually explicit real fast, right? So Ms. Blank's request to seal the amended complaint should be denied. So this court should deny defendant's request for sanctions. So, there is no cause to award sanctions against Mr. Brooks or his counsel. Mr. Brooks was entitled to amend his complaint as a matter of course under the rules, and nothing prohibited him from identifying both parties in the amended complaint. As Ms. Blank observed in opposing Mr. Brooks's motion for joint pseudonymity, pseudonymity is the exception, not the rule. And it was Ms. Blank who argued that there was no basis under Fifth Circuit law exists to grant Mr. Doe's request to seal the record or publicly redact filed documents to conceal the identities of he and Ms. Rowe. Naming Ms. Blank in the amended complaint was consistent with her own stated willingness for both parties to proceed under their own names in this litigation. She should absolutely, like 100%, be pissed at her lawyer. Her lawyer screwed her. Not literally, because I feel like we have to be clear on that with this particular case, but her lawyer absolutely screwed her. So, yeah. For all these reasons, Mr. Brooks requests that the court deny Ms. Blank's motion in its entirety. And they note in the footnote, the only party to publicly assert graphic and explicit allegations is Ms. Blank. For example, her opposition to Mr. Brooks's motion for joint pseudonymity unnecessarily spends 6 pages detailing allegations of sexual assault and rape. Ms. Blank had no legitimate purpose for including such allegations in her filing on a procedural matter such as pseudonymity. They're basically going, y'all are acting real dumb here. All right, so that's the Garth Brooks filing, the latest one. They're getting really in the mud, and I'm betting the judge is just going to come in and be like, children, everybody needs to behave, or I'm driving this entire courthouse off a cliff, right? That's what I think we're gonna see, right? That's where I think we're gonna go. All right, and Wendy Wilkinson, thank you for the gifted membership. Chat, how are you feeling? Because I noticed that we went through an entire filing, and I'm gonna push you guys a little bit more than I have in the past. We went through an entire filing, and there was a gifted membership. So, should I keep going, or are you guys tired out? Because, yeah, I just, I don't know, but, all right. There was one more thing I wanted to cover there, and the thing I wanted to cover was, Andrea Burkhart. Andrea Burkhart has gotten, Andrea Burkhart has, kind of waded into the fray a little bit with the Delphi matter. Now, I'm not saying that as an insult. I am saying that as a, I'm saying that, because she's actually fighting for all of us out there. She's actually helping us all of the things. So we're going to cover that. Mackenzie Jabali, thank you for the 5 gifted memberships. And KPT says, let's go. All right, let's go. And Laura Lee Annie, thank you for the 5 gifted memberships. Much appreciated. Wendy Wilkinson, thank you for the $7.99. Much appreciated. Good old Arky Gal. Not going to lie. Love you, Runkle. I'm also broke AF. That is fair. Ian Paler, editing air show photos. Please keep the law things going. All right. Well, thank you so much. Back after EDB behind the scenes. Sorry, it's all good. All right, so let's look at what Andrea had to file, because Andrea, not only did she have some stuff to file, but her stuff to file was, it's well written, it's concise, it's polite, it's all of the things, and it's really for the benefit of everybody out there. Including myself potentially. Let's have a look at this one. So, let's pull this up. Now, I don't have a PDF here, so we're just going to do it like this. Please tell me I can embiggen this. I can embiggen it this far. Okay, that's as far as we can embiggen it. Now, I don't know if she's going to succeed, but this is in the matter of the state of Indiana versus Richard M. Allen, which you may also know as the Delphi case. The Delphi case is a really interesting case, and it really feels like there is a potential for that there's a potential for a serious miscarriage of justice. For example, there was a bunch of deleted video, deleted evidence in the Delphi case. There was a bunch of, and so it's really, really interesting to see how this one is going. But one of the problems with it is that the judge has decided no cameras. No cameras. And so what does that mean? Well, it means that Andrea Burkhart and others have been attending the courthouse, and she is sleeping on the courthouse steps. And I know personally how much that sucks, because I've been there, right? In the, in the Depp trial, I was sleeping on the courthouse steps, but they are really trying to lock down information. So what's Andrea Burkhart trying to do? She's trying to knock a hole in that. She's trying to get some of that information out. So let's have a read here. State of Indiana versus Richard M. Allen, motion for leave to intervene and for public access to court records. Andrea Burkhart, pro se, which means on her own. She's being her own lawyer here, and I would say that's crazy, except I've done it myself. I've got a gun that is engraved with "paid for by the chief firearms officer," because they won. And L. Fliggins, I'm going to be going through this at some point. There's a really compelling argument against bullet forensics with 2 guns being held, because neither could be ruled out. I'm going to be doing a video on that soon. But for right now, we're going to go over this and then we're going to wrap up because it's late and I have to redo a coaster. So what I mean by redo a coaster, I'm doing a charity auction. There's going to be a charity auction for as part of the 24-hour live stream. And so the charity auction, we're going to be auctioning off a bunch of stuff, which includes some of my leatherwork. And I brought a thing in. So let me show you as an example of the leatherwork. So this journal, and you can see this really cool color. I found this cool blue sort of mottled effect. And it's got my maker's mark on the back. And it's got it's got a little notebook in it. When the notebook is full, you can pull the notebook out and you can replace it with another one. You can buy these, but this was handmade by some asshole, which is me. It's me. This, I handmade this, right? So when you and I don't really sell my stuff. It's really only available as these charity live streams. That may change in future. I don't know. Maybe I'll make some stuff and sell it. But if I do that, it'll just be because I just want to make stuff and then like selling it. But yeah, how did I get the shine? I bought the leather. This is sort of a processed leather. It's real leather, but the coating on it is a process. So this is one of the things that is going to be on the auction. But I'm also making some coasters for it. And those coasters are going to be, those coasters will be, available to bid on. But one of the coasters is stained. I tried to clean it with some, some, what do you call it? Degreaser, basically. And it stained it. And I didn't like that. So I got to redo that one. I'm also probably going to auction off this thing. This is a what is it? This is a little it's got a binder page to it. I made this on a Roll of Law stream. And so it's got sort of a lava orange and sort of black pattern to it. So I'll auction this off as well. I believe that this is the one. I think this is the one I was using for Gimlet's spellbook. So no, wait, was that? I might be wrong. Give me 1 second. Nope, I was wrong. This one was Gimlet's spellbook. This one was Gimlet's spellbook. Does somebody out there want Gimlet's spellbook? Maybe we'll add this. Maybe we will add this one. Yeah, that. All right. So anyway, but I got to redo a coaster. So, but yeah, join us on the live stream. We're gonna do that, and we'll go from there. But for right now, let's get back to this signed brass. Yeah, I could do some signed brass. All right, I'm gonna shrink myself down a little bit here. So, actually, it works bigger. It's bigger and better this way. We'll do it this way. I am an attorney licensed in Washington and Oregon and a legal commentator on a variety of internet-based platforms. At the time of this writing, I have over 89,000 subscribers on YouTube. Guys, if you are not subscribed to Andrea Burkhart, go subscribe to her. I want to see her hit 100,000. So, yeah. At the time of this writing, I have over 89,000 subscribers on YouTube, over 67,000 subscribers on X, formerly Twitter, and over 1,400 subscribers on Substack, where I provide legal analysis and reporting on high-profile cases, including the subject cause, the prosecution of Richard Allen for the murders of Abigail Williams and Liberty German, I'm not sure. Tens of thousands of viewers are watching my coverage of this trial and rely on me for detailed information about the trial proceedings, as well as my interpretations and opinions about what is transpiring. I am not an employee or representative of a traditional press outlet such as a newspaper, television station, or wire service, and therefore do not qualify as media within the meaning of Indiana Judicial Conduct Rule 2.17, Comment 2, or Indiana Code. Now, this is something that needs to change because, quite frankly, the definition of media needs to be different. It needs to be a different thing. So, yeah. And Vidadorno says, Runkle, you can auction the stained coaster for a reduced price for those who can't donate hundreds but want to help. What I really wish I could do, I wish that I could give stuff away. I wish I could just give things away by chance, but the Canadian law doesn't really allow that. I'm going to look over the Canadian laws again and see what I can do as a giveaway, right? What I can do as a as that. So we'll try that, okay? We're gonna give that a shot. So, despite overwhelming public interest in this case, this court has repeatedly denied requests to broadcast this trial to the public, entering orders denying broadcast requests on October 27th and May 16th. The court also denied a request by a news media to record court proceedings by order dated September 11th, 2024. Finally, the court denied a request for recording of court proceedings by Wish TV by order dated October 16th, 2024. Trial in the above captioned matter began on October 14th, 2024, with jury selection in Allen County, Indiana. The trial has advanced to the presentation of evidence beginning on Friday, October 18th, 2024, so just recently. Because the orders denying broadcasting and recording of the proceedings limit the scope and quality of information publicly available about what is occurring during the trial, I have traveled approximately 2,000 miles to be able to attend and report on the trial, which is amazing, right? Amazing. As a result of the trial's inaccessibility to public view, numerous members of the public and the media have likewise traveled to the small community of Delphi, Indiana, in an effort to witness the trial in person. Now, here's where you're going to get to see just how public access isn't super public, right? Public access to courts, they say, which isn't really that public. With the court's allocation of reserved seats to the families of the victims, the defense, and the media, there are 24 seats in the courtroom available to the public. Far more members of the public wish to attend than the courtroom can accommodate, which has resulted in long queues outside the courthouse, beginning as soon as the preceding night. For example, when opening statements were scheduled to be presented on Friday, October 18th, 2024, I arrived at approximately 3:30 a.m. and was already approximately number 22 in line for admission out of 24 seats, right? 24 seats, she was number 22, and she got there at 3:30. I have been further informed and believe that members of the local community who have been personally affected by the crime and would like to attend the trial are discouraged from doing so because of the crowds. I'm aware that Rule 5 of the Indiana Rules of Criminal Procedure requires the trial court to maintain an electronic recording or stenographic record of all oral evidence and testimony, rulings admitting or rejecting evidence, objections, and any other oral matters occurring during the proceeding. The rule requires either a printed transcript or the electronic recording to be produced and maintained as a court record for 55 years in felony cases, such as the present matter. Under Rule 3B of the Indiana Rules on Access to Court Records, Such transcription or recording constitutes a case record because it is an item created or maintained by a court in connection with a particular case, and a case record is a court record under Rule 3A. Furthermore, under Rule 3F of the Indiana Rules on Access to Court Proceedings, public access includes the ability to both inspect and copy a court record. You see where she's going here, folks. This is a really clever attack. This is a really clever approach. Really, really clever. So, public access includes the ability to both inspect and copy a court record. Accordingly, public access is denied if the court does not permit the public to obtain a copy of the transcript or audio recording of trial proceedings. I am further aware that under Rule 4 of the Indiana Rules on Access to Court Records are accessible to the public subject to specific exceptions enumerated in Rule 5 that do not apply to the transcription or recordings of the present trial. Under Rule 4D, while the court may manage access to the audio recording of proceedings to avoid substantial interference with the resources or normal operation of the court, this provision may not operate to deny to any person the right to access a court record. So basically she's saying, I got a right to the records. I've got a right to see all of these records. By this motion, I am requesting copies of the transcription or audio recording of each day of the trial proceeding in this matter, beginning October 14th, 2024, and continuing until its conclusion with a verdict or other resolution. Recognizing that providing the copies will require the use of court time and resources, I am happy to receive the copies in digital format through an electronic medium such as email, or through a cloud-based information storage provider such as Dropbox or Google Drive. Alternatively, I'd be happy to provide thumb drives to the court upon which the digital files can be copied. I'll even give you the drives, court. I'll help you out. Based on my experience in obtaining and transmitting court records in various formats in multiple jurisdictions, I believe that this would impose only a minimal burden on court staff, as it would require little more than dragging and dropping the digital file already created to the storage medium and notifying me that the file is available to be picked up. She's got some spice. She's got some cleverness there. I am aware that Rule 2.17 of the Indiana Judicial Conduct Rules affords the court discretion in deciding whether to allow the independent recording or photographing of the courtroom and the broadcasting, televising, or digital streaming of the trial, and I'm not requesting to revisit or reconsider the court's orders denying the media's requests to allow cameras into the courtroom. Judge, I respect your rulings. I respect that you've already denied the recordings and so forth. I'm not asking you to allow cameras. I'm just asking for the recordings that you're required to let me have. This is effective. However, I believe that permitting the public to witness the trial through the transcription or audio recordings of the proceedings will decrease the distractions in the courtroom and improve the dignity of the proceedings consistent with the courtroom rules by decreasing demand for access to the courtroom, and will further alleviate the burden on the court and the community resulting from competition for the limited public seating that is necessary for direct access to information about the trial. Judge, you've got to have seen this giant circus out front. We can make this circus go away. Just let us report for this stuff online, right? Let us report this stuff online, and all of this shit that is happening out front can go away. Yeah. This will further benefit the community by freeing up the limited courtroom seating for those local residents who've been traumatized by this crime and for whom personal attendance at the trial would be healing. she's got some clever little manipulation there, a little turn of the knife. Yeah. With the commencement of the evidentiary phase of trial, the court has admitted several exhibits proffered by the state and the defense. On October 1st, 2024, a coalition of news media organizations filed a motion to inspect the public trial exhibits. By order dated October 16th, 2024, this court granted permission to the media to view the trial exhibits at the conclusion of each trial day for 15 minutes. 15 minutes? That's not a lot of time. The order makes no provision for any member of the public to view the exhibits on the same terms as the access granted to the media. And the problem is that the public is the media in the modern world, right? The media, and this is the same as what we saw historically. Historically, the notion, Turtle Boy, I gotta say, is the traditional model of the journalist, which is to say, this notion of like journalism is something that you study for, and that you're only a legitimate journalist if you're with like a particular subset of media outlets. That is, that's kind of new. That's not what the original conception of journalism was. The original conception of journalism was basically interested members of the public and sort of, active muckrakers and so forth would just go out and like start a paper. And sometimes those papers were like literally just, a lot of the early journalists, like in the era when the First Amendment was fucking drafted, were people who would go out and report on something and then stand on a soapbox with like a cup out in front of them, just telling you the news, and people would throw money in the cup as a thank you, right? And so the model of Turtle Boy is actually closer to that than is like the New York Times. The New York Times is, the New York Times is a different thing entirely. And the problem is that journalism itself has become somewhat captured. What I mean by that is that if you saw the Johnny Depp and Amber Heard trial, you'd probably be wondering why all of the news media was coming out so hard. Why they were coming out so hard for Amber Heard. And the thing is it's because she hired publicists. And a lot of the news media is super lazy. And so what they rely on is they rely on coverage by access. And what I mean by that is that they're relying on getting the news from the people they're reporting on. Well, the problem with that is that if you're relying on that access and you're relying on those people who can take that away, then you have to provide coverage that's favorable to them. You will see this online. Go online and watch reviews of products, right? Watch product reviews. And you know what? Most product reviews are glowingly in favor of the product. And you know why? Because those product reviews are done by people who got the free product from the review company. And so they do a review that says how great the thing is, because then they want to get more stuff, right? But you also get things like people who report on a company don't want to say something bad about the company, because then if they do, they don't get access anymore. And the other thing is, like, a lot of the news reports about the police, tons of news reports about the police and what they do, are purely done by taking the police report and regurgitating it. Like, it's literally like what a mama bird does to baby birds, right? They eat the police report, they chew it a little bit, and then they spit it into your mouth. And what you get is basically the police report with a few words changed. It's gross. And it means that if, you have these news reporters who are like, they're dependent on being able to be invited to these press releases. They're so the fact that nowadays we have people, and I mean, a lot of the time I will read a news story and I will go and look at the case, and the news story is completely wrong about the court case, right? It's just completely fucking wrong. It's just so bad. One of them basically said that this guy was acquitted. I read a story a little bit ago, and the story said, man acquitted of sexual assault because he believed he was entitled to sex. And the thing is that what actually happened in the court case is that the guy said, like, the guy made that argument, and the court properly said, no, you're not, and that argument is bullshit. But they also said, because of massive problems with the complainant's evidence, which was that the complainant told multiple different stories at multiple different times, the judge said, I can't convict here. But the judge actively rejected this guy's notion about, about this thing. And the news story reported it as if that was the story. It is so awful. So what I'll end up doing is I'll end up reading news stories, and there'll be news stories that piss you off. And then I'll go and actually look at the case and unpack them and go, oh, that's not at all what's happening here. This is so wrong. This is so not the story. I just recently on Twitter, I mentioned a thing where they were talking about the Diddy case, and they showed maybe I could pull it up. They showed a rifle magazine, and they said, oh, this rifle magazine, I'm just trying to find it here. It's just going to take a second. Here we go. I'm just going to move my Twitter thing. Here we go. Here's the picture. This is the mainstream media, right? It says, a magazine for an AR-15. Well, you can't see it because my face is in the way. Let's move my face. A magazine for an AR-15 loaded with large caliber 233 ammunition. Federal prosecutors allege it was found in Combs' bedroom closet in Miami, U.S. Attorney's Office, Southern District of New York. 233 ammunition doesn't exist. It's 223 ammunition. And 223 is not large caliber. It is small caliber. And the thing is I don't know if it was the U.S. Attorney's Office that made this mistake, or if this was the news company that made this mistake. But this is a lie. This is bullshit. This is straight up misinformation. 223 ammo is some of the smallest centerfire rifle ammunition you can get. It's tiny. So, but the media doesn't know any better, and they rely on, this drip feed and so forth. It's like, I just don't. It is, it's frustrating. And so it's really important that these members of the public who are acting as actual journalism, like actual proper journalism, in a way that we haven't seen in a way that is like a new re-emerging thing. like a lost tree that we thought was extinct suddenly coming up from the ground again. This is important, guys. This matters, and this matters hugely for some big Canadian cases. So by order dated October 16, 2024, this court granted permission to the media to view the trial exhibits at the conclusion of each trial day for 15 minutes. This order makes no provision for any member of the public to view the exhibits on the same terms as the access granted to the media. During the trial, paper exhibits have been published to the jury by simply handing them the exhibit or copies of it to review. These exhibits cannot be seen by the public seated in the gallery of the courtroom. Digital exhibits have been published on a large screen that is oriented to face the jury box. This screen has not been visible to some of the seats in the gallery. Consequently, the only way for members of the public attending the trial to be assured of their ability to view the exhibits that have been introduced is through public access similar to that afforded to the media attendees. I was present in the courtroom at the conclusion of the trial day on October 18, 2024, and observed that the proceeding for viewing the exhibits was to place the exhibits on a table in front of the jury box and invite the media into the well to view them for the allotted time period. I am informed and believe that a member of the public attempted to enter the well to view the trial exhibits on Saturday, October 19, 2024, at the conclusion of the trial day on the same terms as the media, and was prohibited from doing so by this court, which ordered this individual to leave. Now, I know some people have identified this individual. Andrea's chosen not to, so I'm also choosing not to. The Indiana rules on access to court records establish no basis for distinguishing between media and the public in affording access to public records. There's Zora running around. So Zora has got some opinions. See generally Rule 2A, all persons have access to court records as provided in this rule. Likewise, it has generally been held that the First Amendment does not guarantee the press a constitutional right of special access to information not available to the public generally. Why? Because the First Amendment applies to everybody, and the First Amendment was written at a time when the press was the public. They were the same people, right? There wasn't that differentiation. The First Amendment right of access to criminal trials is a right held by the public, not the media. The media isn't special. And this is really important for the First Amendment to exist properly. Why does this matter for the First Amendment? Well, because if the government can say that these rights of access are only available to the media, they then get to decide who is media and who is like the peasantry. And if they can identify the media as getting these rights and the peasantry as getting nothing whatsoever, well then, they can decide who gets pulled. And so the inconvenient people in the media, they can just pull out and throw into that public peasant box. This basically says that if you get to, you get to do that. So, I'm going to interrupt here for a second. Harmony saying I'm way behind, but I have to say it's not just Asheville, North Carolina that's hurting. My county and East Tennessee and counties around me are still recovering from Helene. Please don't forget us. I know you're way behind, so you're not going to hear this, Harmony. Please let me know if you're okay. We're just going to put that there. All right. So it is my intention and desire to view the exhibits under the same conditions as those afforded to the media. Let me in on those 15 minutes. My doing so imposes no additional burden on the court, as I would simply enter the well to view the exhibits, the same as members of the media are allowed to do. The court, I mean, it might put some restrictions. Maybe they have to allow 30 minutes. This court's prior exclusion of a member of the public from the same viewing opportunity deters me from doing so out of fear that I will be banned from the courtroom and prevented from continuing to report on the events of the trial. By this motion, I am requesting to modify the court's October 16, 2024 order to permit members of the public who have obtained seats allocated to the public for that trial day to view the exhibits on the same terms and under the same conditions as the access afforded to the media. I have reviewed the published order denying writ of mandamus and prohibition filed by the Supreme Court of Indiana on December 11th, 2023, under Supreme Court case number. That proceeding concerned the omission of court records from the chronological case summary in the present cause. While ruling that the petition was moot because, subsequent to the petition's filing, this court restored the omitted items to the chronological case summary and made them publicly accessible, the Supreme Court nevertheless reviewed the requirements to seal court records from public access, stating in conclusion, we expect all Indiana courts to comply with these rules. So, yeah. Let's see. What is it? I'm just trying to look here. Just trying to read here. Somebody said, I mixed up the name of a hurricane and a person. Oh, sorry about that. Does anyone have a copy of this filing? It is available on Andrea Burkhart's Substack. It is fully available. How much of this is because it involves crimes against children? I mean, the thing is they could limit some of that. But in the present matter, the entire case has not been sealed pursuant to Rule 5A, and the requested materials, audio recordings or transcriptions of the trial proceedings required under Criminal Procedure Rule 5, and the exhibits admitted at trial do not fall under any of the enumerated documents that may be sealed pursuant to Rule 5B of the Indiana Rules on Access to Court Records. Consequently, the materials may only be withheld from public access after following the notice and hearing procedure required by Rule 6 and based upon findings that, 1, the public interest will be substantially served by prohibiting access. 2, access or dissemination of the court record will create a significant risk of substantial harm to the requestor, other persons, or the general public. Or 3, a substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting public access. Here, where they're allowing access to the media, I think it's fair. So, yeah. No such proceeding has occurred in the present case, and in any event, the required findings cannot be made both because the trial proceedings and the exhibits are readily available to the media and the public in attendance. I respectfully submit that this request must be granted under the applicable rules cited herein and the Supreme Court's order. I further submit that this request is consistent with the strong societal reasons for allowing public access to court records recognized by the commentary to Rule 1 of the Indiana Rules on Access to Court Records and the Supreme Court's order. So, wherefore, based on the foregoing, the court is respectfully requested to enter an order providing as follows. 1, granting the motion to intervene for the limited purpose of requesting public access to court records in the present case, which they could just deny the motion to intervene, and then that ends everything. 2, directing the court reporter or clerk of the court to provide a digital copy of the transcript or electronic recording of the trial proceedings each day by email, cloud-based storage medium, or a thumb drive provided for that purpose. And I suspect that if Andrea gets this, she's going to share it because she's always done that in the past. 3, allowing members of the public who are present in the courtroom each day or each trial day to view the trial exhibits on equal footing with the access afforded to the media under the court's order. Respectfully submitted this day of October, Andrea Burkhart. So, I just want to say Andrea's filing here is incredibly badass. So I was already a big fan of Andrea's. I am now a much bigger fan of Andrea's. So And if Andrea makes this open to cover, then maybe I'd be able to, like, okay, I'm going to do some coverage because now I can actually know what the fuck is going on. I am likely going to consider or going to do some coverage because I've got copies of the what do you call it? The filings on a firearm issue. So I want to look at that. Yeah. Terry Birrell says, didn't Andrea shell out a ton of money for the debt transcripts? Am I remembering right? Yes, although she did fundraise for that. Yeah. Andrea is awesome. And again, if you have not, if you haven't subscribed to Andrea, I would really encourage you to do so. Let's go through super chats here. I just wanted to kind of cover that and basically to tell you how awesome Andrea is, right? So, yeah. Andrea might be donating something for the auction. She said that she would try to do so. I don't know if she's been too busy right now, but we'll see. I'm gonna try to we're gonna try to do that. So yeah. All right. So let's have a look at the super chats and we'll go from there. All right. Moving on here. And the other thing I just got to say is Andrea's writing is excellent. That was very well written. It was very persuasive. And I think the court is going to screw her over. What I think the court is probably going to do is something like, hey, we will hear your motion after the trial. So, yeah. I don't know if you answered this already. Is Emily donating something to the auction? I asked her if she would. I haven't heard back, so I'm assuming not. But I did ask her if she'd donate something, and I have not heard anything back. So, don't know. Yeah, I can't say. So, all right. Yeah, Andrea, like, that is really good writing. So, huge fan of her work. Amazing stuff. And, yeah, Kelly told us, so what I'm hearing is look at Andrea's writing as examples to get me through my legal writing class. Yes. Yep. Yeah, Amanda Lang says, Andrea says she suspects the judge will find reasons to ignore it, so it can't proceed. I suspect that what the judge will do is either deny the application to intervene and just say, I'm not hearing from any interveners at this time. Or will say, your motion to intervene is granted, but I will hear the rest of it. I'll hear the rest of it later. So the rest of it we're going to hear after the trial, at which point, yeah. That's what I suspect. So Judge Gull won't let them have water in the courtroom. She made them line up after the morning session, so Andrea didn't get to eat lunch. It is despicable. That is gross. That is really awful. The KKF 1015 says, Runkle, thanks for streaming so late. Keeps me company for writing my master's thesis. Good luck on that one. Gull is going to ban Andrea. Yeah, it might. It's possible. Sinbad 333 says, please let it be boxing gloves. No comment until I can confirm. So, but Laura Annie, thank you for the 5 gifted memberships. Much appreciated. Kimchi, thank you for the gifted membership. Jeremy Morton, thank you for 10 gifted memberships. Much appreciated. Elf Liggins, $2 for Soapbox Cup. Thank you so much. Kyle Fox, $5. Small caliber, 22 Magnum. Fair. All right. So, I think that's, what is it? And Kristen M96 says the robots passed customs. Awesome. Doing some legal reading today. Wonder if you could explain interrerum arguments. That basically means agree with me or really bad shit will happen. That's kind of the way that works. So it is now 10:30. We've been at this for almost 4 hours. I think I'm gonna wrap things up. There are some things I want to cover. Cat W saying more cases and stories. We could. Leather live stream tonight. I could for a bit. Because I do need to finish that coaster. We could do that. I gotta say though, I am also what is it? No, argumentative ad baculum is a little different. Argumentative ad baculum is basically do the thing or I hit you. Is argument from the stick. It's do the thing because I have a stick, right? So I could totally hit you with the stick. That is the argumentative ad baculum. An interrerum argument just basically means like, it's if you don't agree with this, then everything will go crazy and so forth. So cats will start hanging out with dogs, the forests are going to catch on fire and all of these things. So it's a little bit there's a little bit of a distinction there. But an argumentative ad baculum can be taken to the broader sense. But yeah. Now interrerum also depends on the context, because interrerum can be used to refer to threats, like legal threats. So yeah. Yeah. All right. Let's just see here. Let's see. Yeah, Runkle has already been coughing. He needs to recover from his illness before the charity stream. Long day between the trial, EDB members only, then this stream. Time to read, then try to sleep. Yeah. And I appreciate everybody who made it here, because I know there was a lot of competition for your time today. So, yeah. Runkle, this quote belongs on your soundboard. They say that a man who represents himself as a fool for a client, as God is my witness, I am that fool. Gomez Adams family values. I will try to track that down. Yeah. All right. People are like, do we have one more story that we can cover before we one more story that we can cover? I think we probably can. All right. I've got some people who are like, we don't want to go yet. We can do one more. All right, let me pull this up here. Let's see. We're going to cover a story from the news. Failure to provide necessities of life. Durham cop charged in an on-duty incident. So, a Durham police officer has been charged criminally after he allegedly failed to render medical assistance to a person in distress. So basically what they say here is that the police officer showed up for a service call, and somebody got was injured or was was not well. And so that individual was then subsequently taken to hospital for treatment and later released after the guy instead, the police officer just instead failed to provide any treatment. Vidadorno says, Runkle, have you seen the new motions from the Commonwealth in the Karen Reid case? I haven't yet. Terry Birrell says, have you been following YSL? I've been watching daily updates, and last week was a bit wild. Cop almost caused a mistrial and then got kicked off the witness stand. I did hear about that. I haven't watched the footage entirely. So basically, this guy has been charged. What is failing to provide the necessities of life? Well, we can pull that up on Canly. So Canly Criminal Code. We're just going to pull that up and yeah. Thank you so much for covering Garth Brooks. I was hoping you would because I wanted to know the facts. Also, please release YouTube Shorts clips of Doll's explanation. That one is that one's tough. All right, so let's look at the that one. So we'll just pull this one up. Here, oh, that's real small. So, duties to provide necessaries. Everyone is under a legal duty. 1, as a parent, foster parent, guardian, or head of a family, to provide necessaries of life for a child under the age of 16. So what that means is if you've got a kid who's under 16, you can't starve them. And you can't kick them out of your house without provisions, right? Yeah. B, to provide necessaries of life to their spouse or common law partner. Now, this one is not going to be hard for me, but I'm not allowed to, like, starve Mrs. Runkle. And vice versa. Mrs. Runkle's not allowed to starve me. Now, I mean, that doesn't mean that she has to make me dinner or vice versa, but like she can't like keep me locked in, she can't like keep me locked in a basement and, keep the fridge padlocked. More likely on the spouse or common law partner. Let's say I got really sick, right? Let's say I got injured and I was like absolutely bedridden. I could not get out of bed, right? Mrs. Runkle might actually have an obligation to like come down and feed me, right? If I was bedridden and all of that, and vice versa. Now, I think me and Mrs. Runkle wouldn't have a problem following that obligation, but it's there. And we have another provision here to provide. So none of these really apply. Neither A nor B applies to the cop, right? So C, to provide necessaries of life to a person under his charge. So under his charge is a little more broad. If that person, 1, is unable by reason of detention, age, illness, mental disorder, or other cause to withdraw himself from that charge, and 2, is unable to provide himself with the necessaries of life. So, you'll notice here that detention is specifically mentioned, which seems to me that it includes police officers, right? If a police officer arrests you, they are required to make sure you're okay, right? They can't like arrest you and detain you in custody and then not feed you, right? Yeah. So basically, that is what the officer is being charged with. What could he face? Well, the punishment is a maximum of 5 years. So he's not going to go all that far. So Indigo asks, aged cheddar cheese, your favorite beer, a small amount of sodium citrate, warm it in a small pot, use an immersion blender to blend it, then stir in some burn your regrets. And I saw Indigo was saying, I mixed in a healthy amount of everybody makes mistakes into cream cheese and dipped chips into it. I can't finish it all tonight. Oh, that sounds good. I'm sure that sounds really good. And so yeah, I'm glad you guys are liking the hot sauce, because I was super worried about whether you guys would like the hot sauce. So we don't know exactly what's happened. They haven't revealed a whole lot of details, but is this cop going to get 5 years? He's not going to get 5 years. He's going to get something less than that. He's probably going to get, like, if he gets anything, if he gets convicted, he will probably get a, he'll probably just get, yeah. So, yeah. All right. Any other questions here before we go? Do I have hot sauce Yes, I have every kind of imposter syndrome. I want the hot sauce. I love hot sauce. I am sold out of the hot sauce for now, but I am there will be more. And the next time there's hot sauce, I am going to we're going to get it so that we can ship it to the US. The US is fairly restrictive. They say you can't ship foodstuffs there unless you are unless you have an FDA registrations. So I got to get that lined up before that. So we're going to make another round. And I'm working on additional new hot sauces. So we're going to remake the Burn Your Regrets. We're going to remake the, Everybody Makes Mistakes. But I'm also hoping to make a new one that I already have a provisional, name for. And the provisional name is Lime and Punishment. We're going to make that. That's the plan. There's another one that I'm planning on making that is, what do you call it? That I don't have a name for yet, but we're just trying to, that it's going to be like a no onion hot sauce. So no onion, and it may be a little weird, but I'm going to play around. Cat W says, thanks for tonight's stream. And we got a Zora pup. CB Fixes All, what new handgun did you buy? So I just bought a Sig Sauer P365. It is a prohibited firearm, and that is through my business license. I see no onion, no cry. I'm thinking about calling it. I was actually thinking about calling it like something like no onions, just tears might be a good one. No onions, just tears. Is that a bad name? So yeah, well, I'm just yeah, we'll figure it out. I'm gonna experiment. So I was going to I thought if I ended up making one that is green tea flavored, which is one of the flavors I'm going with, that I could call it like a green dragon. Somebody else already went with that one, so I can't do it. No onion, all cry. Fair. Not as good as Lime and Punishment, but it's decent. I can still work on it. I can still think about it. Can I cover an archery themed case? Yeah, probably. Steven says the easiest hot sauce is roasted chilies, then into the Vitamix. Yep, that works. The other thing you can do with the other easy way to make hot sauce is just ferment the peppers and then blend them. So, all right. All right, let's wrap this up here. It is getting a little late. I am what is it? Yeah, we can go and do a coaster. We'll do another coaster. I'm gonna tell you what, I'm gonna end this. I'm gonna take a breath. I'm gonna take a little moment to, like, honestly, I'm gonna take a moment to pee. Sorry, I guess I shouldn't have said that, but I will do that. And then I'm gonna go to, it'll be a short leatherworking stream. It's just I gotta make one more coaster. But then we'll do that. So it'll be short, and then we'll now I want to do dying. Fuck, we might end up doing dying. Okay, I'll see you guys on members only in a little bit. So good night, everybody.